Okay. Crystal, are you walking us through housekeeping?
Yeah, I'll go ahead and get that started. Welcome, council members, liaisons, and members of the public to the December 3 Council on Access and Fairness meeting. Thank you for joining us. We will begin shortly. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you'd like to comment during the meeting, please use the raise hand feature. To use the raise hand feature by phone, dial *9 on your phone's dial pad to raise your hand and the same to lower your hand. Please utilize this tool to virtually indicate that you'd like to speak in order to help the chair facilitate the discussion. New going forward, all commission and committee meetings will be recorded and posted on the State Bar website. A friendly reminder that this is a video conference and to please be aware of your surroundings behind you. A few troubleshooting tips for those using Zoom on a computer. When on mute, holding down the space bar will temporarily unmute you. If you use your phone to dial into this meeting, please be sure your computer's microphone is on mute to avoid audio feedback issues. And while joining audio via computer is highly recommended, if an individual loses audio, they can call in separately using the Zoom conference number.
Great, thank you.
Thank you, Crystal. Hi, everyone. Nice to see you all. As chair of the Council on Access and Fairness, I'm glad that we are back in gear, and I would like to go ahead and turn it over to a roll call vote so that we can see who is here and we can establish a quorum.
Okay. Ryan Harrison?
Here.
Judge Kristen Rosie? Heather Anderson?
Here.
Novella Coleman? Sarah Good?
Here.
Michael Rhodes?
Here.
Sherlock Richards?
Here.
Angelica Salceda?
Here.
Stephanie Santoro?
Here.
Sal Torres?
Present.
We have a quorum. Should I'll run through our liaisons. Pat Lee?
Here.
Kenneth Wang? Judge Judith Dulcich?
Here.
We have Board of Trustees liaisons who are not present today. And I also just wanted to recognize that we also have Kathy Ungary from the Judicial Council, who's may chime in during the Judicial Council liaison report.
Thanks, Elizabeth. All right, let's move on to public comment. Do we have any members from the public who wish to speak?
Okay, Arita Guthrie, I've unmuted you. You're muted.
Unmuted. Okay, do I have to hold this down?
The space bar, I think so.
Okay. All right. My name is Arita Guthrie. I am an attorney and I live with 2 types of disability. My comments today are brief, but they will touch on many items on today's agenda. My mission is to educate our society about disability, in part by pointing out microaggressions and inequality. I am nervous today because this is always a difficult conversation, trying to advocate for my community without being adversarial or judgmental. In that spirit, I respectfully submit that my review of the bar and its committees shows a lack of inclusion with respect to people with disabilities in the justice system. With respect to this committee, I have seen several microaggressions that I would like to see addressed. At the last meeting, there was a discussion of the anti-discrimination provisions in the rules of professional conduct. Some members were not even aware that disability was included in those protections. Disability awareness and education needs to be increased. The diversity reports issued by our bar put disability last. Many of the titles put disability last. Many of the charts, graphs, and tables put the category of disability at the bottom. We seem to be the last group to be studied or included in diversity initiatives. And I'll give one example. In the March 2021 BAR report, there were 3 lengthy paragraphs on new demographic information requirements for law schools. It focused solely on one category of the student population. Then there were 3 brief sentences about future phases of reporting information. Disability is again mentioned last. Please understand that I know all of the social groups being studied are very important. I am not suggesting that disability is more important than other groups, but it's not less important either. And right now, disability has not appeared in the forefront of the diversity discussion. Please understand that there are many, many more instances that I have left out, and it was excruciating not to talk about them. But this isn't a zero-sum game. Occasionally putting people with disabilities first doesn't exclude other groups. In fact, disability is the only group in society that intersects with every other group. We are every race, religion, gender, sexual orientation, income level, and more. Raising our boat raises everyone's boat. As I said, it was very hard to limit my comments to these few issues, but I will close by saying that I believe that everyone on this committee understands microaggressions and has the best intentions. But we need greater awareness of microaggressions toward people with disabilities look like and what we need to do to change. Specifically, the BAR survey doesn't gather information from attorneys who have been shut out of practicing due to a disability like me. And also the survey isn't anonymous. You can't ask someone to admit something they perceive as a weakness until we first establish clearly and loudly that disability is a natural part of human existence and that discrimination won't be tolerated. I'd also like to note that going forward, Prop 209 doesn't include disability and therefore doesn't place limits on what can be done. Thank you for your time.
Thank you, Ms. Guthrie. Your comments were well received and we'll certainly follow up on them. Are there any other members from the public who would like to make public comment?
I don't see any other hands raised.
All right, thank you, Elizabeth. We'll move on to the chair's report. I think this is a great time to go ahead and kind of reacquaint each other with ourselves and to introduce our newest member, Angelica. And so what I'd like to do is just go ahead and facilitate an introduction for all members. And Elizabeth, can you help me with calling out names so we don't kind of skip over people? All
Sure.
right, thank you. And I'll start with myself. So my name is Ryan Harrison. I'm an attorney at Jackson Lewis. Attended UC Hastings. I have a twin brother who's also a lawyer, and I'm here to focus on diversifying the legal profession, a passion of mine. And so we'll go ahead and go to whoever's next. I'll let Elizabeth call out names.
Okay, Heather.
Hi, everyone. I'm Heather Anderson. I am an attorney in Southern California in Los Angeles. Until a couple of months ago, I was an attorney at a major media company, and now I am a former attorney at that major media company in a business role. Nice to meet all of the new people.
Okay. Sarah.
Hi, everybody. I'm a partner and chief talent and inclusion officer at Farella, Braun and Martell in San Francisco. We're a mid-sized firm of about 120 lawyers. I've been practicing for over 30 years, gulp. In my new role, I'm focused on diversity and inclusion, and in particular, trying to grow and develop the next generation of lawyers. So nice to meet the newest members. Thanks.
Michael.
Good morning. I'm Michael Rhodes. I use he and him pronouns. I am an attorney at the California Supreme Court for our Chief Justice. I live in San Francisco. And I'm also an adjunct at McGeorge, and I coach Moot Court Hastings, which has taken up a lot of time recently, but is really a joy in giving back for sure. And yes, I feel the same way talking to students and reflecting on how long ago it was that I was in their shoes and then thinking, oh boy, it's only getting more time from here. Good to be here.
Thank you, Michael. Shalak?
Good morning, everyone. Shalak Richards. I am Associate Dean of Student Life, Diversity, and Belonging at Pepperdine Caruso Law. So I get to work intimately with all of those students who remind me daily that regardless of my skincare routine, I am not as young as I once was. And when in practice, I practiced immigration removal defense and was regularly appearing in the immigration courts. And it's a pleasure to be here.
Angelica?
Hi, everyone. Angelica Salceda. I am the Democracy and Civic Engagement and Program Director with the ACLU of Northern California. I'm based out of our Fresno office. A lot of my advocacy work in the past has been to really help close the justice gap in rural California, including in the Central Valley. So very excited to be part of this council and just excited to be able to tackle on some very important issues to make sure that our profession is more diverse in a lot of different ways, including geographically, and also very thankful for the comments that were made earlier during the public comment. So thank you for that.
Thank you. Stephanie?
Hi, I am Stephanie Santoro. I am a Deputy Attorney General with the California Department of Justice. I'm based in Los Angeles. I practice criminal appellate law. I'm also a co-coordinator of our student law clerk program. So we are also trying to push diversity and inclusion and foster that in our office. I look forward to working with everybody.
Thank you. Sal?
Good morning, everybody. Sal Torres. I am the Senior Director of the Americas Commercial Transactions team of Equinix. Equinix is the world's largest platform company with over 290 data centers all over the world. At Equinix, I'm also the leader and founder of Equinix Gente Connect. It's one of the employee resource groups we've created to bring more diversity, inclusion, and belonging to the company. And Aretha, I really did appreciate your comments. And I want you to know that in the private sector, we think about these things too. And in fact, we just, in my capacity there at Equinix, I'm also part of the diversity inclusion group, which brings more employee resource groups to fruition. And the latest one we just premiered a couple of weeks ago was Abilities Connect. So this is encompassing the folks that are of the abilities community. And I've been practicing law for about 32 years. I know you can't tell from my gray hair, but there it is. Good morning, everybody. Thank you.
Thank you, Sal. Pat?
I'm Pat Lee. I'm the liaison from California Law Pathways, which is a program that focuses on expanding the pathway from California Partnership High School Academies to community colleges, to law schools and their undergraduate counterparts. I'm also chair of the ABA Standing Committee on Public Education and former chair of the Diversity and Inclusion Center.
Thank you, Pat. Judge Dulcich?
Hi, everyone. I'm Judge Judy Dulcich. I'm a Superior Court judge in Kern County, California, in the Central Valley. I'm up there as far as practicing and being on the bench with some of the others of you. And I'm on the Judicial Council's Advisory Committee for Providing Access and Fairness, and I am your liaison for the Judicial Council, and I'm so happy to be here. Thank you for having me.
Thank you. So I think we've run through everyone present, Ryan.
Thanks, Elizabeth. Okay, let's go ahead and move on to the consent agenda. I want to ask if there are any comments that anyone has on the August 27th meeting summary or the minutes. And if not, may I have a motion to go ahead and approve that meeting summary?
So moved.
And a second, please.
Second.
Okay. Okay, I'll do a roll call. Ryan,
Yes.
Judge Rosie, Heather,
Yes.
Novella, Sarah,
Yes.
Michael,
Yes.
Shalak,
Yes.
Angelica,
Yes.
Stephanie,
Yes.
Sal.
Yes.
Okay, motion carries.
All right, let's move along to item number 7. We're taking this out of order. This is a training that we're going to receive on the Bagley-Keene Open Meeting Act.
So our trainer, our Associate General Counsel Brady Dewars, not yet here. We're running a little bit ahead of schedule. I can do our access and inclusion staff update, if that's okay, while we're waiting.
Sure, let's go ahead and do that.
Okay, so good morning, everyone. I'm Elizabeth Hom. I'm primary staff to the Council on Access and Fairness. Welcome. I just wanted to give a quick update about our office. As a reminder, and for those of you who aren't aware, the Office of Access and Inclusion at the State Bar, we also administer grants to legal aid organizations throughout California. So for 2022, we'll be we work with the Legal Services Trust Fund Commission, and we will be distributing about $135 million to legal aid organizations throughout the state. We fund about 100 organizations. And so in addition to that, we also staff various access to justice initiatives like disaster legal services coordination, as well as administer the pro bono practice program. So we are currently recruiting for a program analyst as well as a senior program analyst for our office. So if anybody has any folks who might want to work at the State Bar and in our office, which has a very specific focus, please let me know. And then shortly we'll be onboarding a senior financial analyst as well as another program analyst. So we are quite busy in our office, but I just did want to share that so that you kind of understood the staffing for this. I know a lot of you have worked with various staff of ours in the various working groups. And so I think in the new year, you will see some new and some familiar faces.
Thank you, Elizabeth.
You're welcome.
Anybody would like to comment on the staff update for the Office of Access and Inclusion? All right, let's move on to item 5B, which is update on efforts to reform the attorney discipline system.
So I'm sorry, the staff, I had set some times for the various staff to come in. And so since we're running early, they're not quite here yet. Brady should be here. I just pinged him to join a couple minutes early. So hopefully he should be joining any moment now for the training.
Okay, are there any items that we can proceed onto, or should we?
Crystal, actually, do you mind providing an update on law school retention?
Sure, it's a very brief update. So in September, Elizabeth and I presented preliminary findings from the law school retention study, which is the survey as well as the enrollment and attrition data analysis to the law schools at the Law School Assembly. Good news is that the law schools were very receptive to the data and very open to potentially participating in focus groups to discuss some of the data highlights more in detail to provide more contextual information. Our first focus group is scheduled for December 16th, focused on academic support programs and non-academic support. So looking forward to reporting back to the council with how that goes at the next meeting. And then we'll also have some subsequent focus groups in January, just based on other data. We're getting data as we have, and I think we're coming closer to developing the report and final resource. So that's great to get additional insights from the law schools at this point.
Thanks, Crystal. Out of curiosity, is UC Hastings participating in the December 16th focus group?
We're still gathering the attendee list, but I hope so. I will coordinate with yeah.
And, if you have a specific contact for us, that would be great. Sometimes it is hard for us to get the attention of law schools, so we would appreciate the contact.
The specific contact should be the director of the Legal Education Opportunity Program. I think her name is Tracy McGrath. That program provides a lot of academic support for diverse students. Typically, about 20% of UC Hastings students are admitted through the LEOP program. And that program is designed to diversify the legal profession. And so I think the support programs offered through LEOP could be helpful. I am a person who went through UC Hastings through LEOP. And so that's why I'm making that recommendation. And we have some other hands raised. I see Sal's hand first. Go ahead, Sal.
Thanks, thanks, Ryan. Crystal, two things. One is if you could make a list of all those participating available to us, that would be helpful. Specifically as to the University of San Francisco School of Law. If they are not participating already, you can contact Carol Wilson. She's the head of the academic support program there at USF. It's Carol Wilson and also Professor Heidi Ho, that's H-O at the end. And those would be contacts for you to go through as well. Thanks.
Shalak?
I was going to say something similar, Crystal, that if you tell us who's participating, perhaps we can help you fill in the blanks to reach out to schools that have not been. Of course, I'm not sure how large you want that group to be, so you can also give us a framework on, you know, how many schools you want to be present at that focus group versus future ones. If no one is participating or has signed up from Pepperdine, please let me know. Our academic success programs will be shifting to report to me very shortly, so I will just make sure that they participate. Thank you.
Heather?
I was just going to reiterate all of these things, including if you need contacts at UCLA Law, happy to put you in touch with them if they're not already participating.
Thank you, everyone. I know that we're coordinating with admissions to make an announcement. I believe that was sent earlier this week to both the CS Bars and the Law School Council. So I will follow up in terms of who signed up so far.
Thank you, Crystal. All right, Elizabeth, who can we move on to next?
Brady has joined us, so we can have our training now.
Excellent.
Hey there, everybody. I'm Brady Dewar from the Office of General Counsel. So I'm having some technical difficulties with my home network, so I'm now connected over cellular with my phone. So Elizabeth, did you see the PowerPoints I sent you?
Yeah, so let me,
because I can't run those from my phone.
sure. Do you want to start with Bagley-Keene?
Sure.
Okay.
So let me get this up on my computer also. Let me just take a step back. My name is Brady Dewar. I'm with the State Bar's Office of General Counsel. We are the basically the in-house law firm for the State Bar, and we advise staff on any legal issues that might arise. Runs the gamut from employment issues to policy issues and how to comply with the various requirements on us as a government agency. And that extends to also advising State Bar sub-entities, commissions, and councils, such as COAF. I think many of you have had this training before. We try and do it every year, but the point of this is just to make you aware of a few of the compliance issues that come up for a sub-entity such as COAF. The first presentations on the Bagley-Keene Open Meetings Act and the California Public Records Act, both of which affect COAF as a part of the State Bar, which is a public agency. This slide presentation is pretty detailed, and if any of you are interested in the details, we can share it with you. I'm going to go a little bit high level because most of the details here are really things for staff to worry about and for us to take care of the compliance. And I'm going to focus on how these two laws might affect you. Next slide, please. For those of you who might be long timers or have served on other state bar committees or commissions in the past, the state bar was not subject to the Bagley-Keene Open Meetings Act until April 1st of 2016. It was state bar because it sits under the judiciary and is somewhat regulated by the legislature. It's a bit of a unique creature in state government. So for a time, it was not subject to these requirements, and now it is. Next slide. Sub-entities of the state bar, committees, commissions, working groups are subject to Bagley-Keene if they are created by formal authority, either by the Board of Trustees or by statute. So COAF falls into that. Small working groups, if staff puts together a group of just 2 or 3 of you on an informal basis to work on a project, that separate working group would not be covered by Bagley-Keene. It needs to either come from formal action of a body such as the Board of Trustees or COAF, or be formally created in rule or statute. Let's skip the next slide. So Bagley-Keene Open Meetings Act is a series of rules that apply to commissions, committees, boards within the state government of California. There's a very similar act that also applies to local government agencies. And the purpose of this, it contains requirements for public access to meetings, notice requirements so that sufficient notice is posted on the website of what will be discussed at any meeting in advance of the meeting, to give the public a chance to attend, participate, make comments. And the purpose here is really that we're doing the business of the public, so we should do the public's business in public. We want to give notice and opportunity to participate. And if disputes come up, which admittedly are rare, the courts and the California Attorney General usually broadly construe the rules in favor of greater public access. So we try and go above and beyond. Some of these rules, and the ones that affect you most, have to do with not having sort of side discussions, side communications amongst yourselves about council business outside of a meeting. And we'll go into the specific rules on that. A meeting under the Bagley-Keene Act is any time that a majority of members of the body, COAF in this case, meet together to discuss something. So if 2 or 3 of you are having a conversation, that's not a meeting. But Elizabeth, can you remind me of the number that we have now? Is it 17?
No, 10.
Oh, 10.
Yes.
That's confusing with a large group. So if 6 of you get together and meet, that is a meeting. And under Bagley-Keene, you can only meet if it's a noticed meeting, an official meeting that the public is made aware of. There's going to be a slide on this, but I think I should highlight it now, because this is the one key item that I think you guys need to be aware of, is that a meeting is not just all of you present in the room at the same time. It's not even necessarily a conference call. It could include emails or even social media conversations. So if 2 of you have an email conversation together about something within council business, and then one of you forwards it to another member, and then that person chimes in, and then it gets forwarded to another member, and pretty soon it's a email thread that's touched 6 or more of you. That then is a meeting, because 6 or more of you have discussed this issue, whatever it is, that is council business, outside of a notice meeting. And obviously those private emails of you are the public isn't put on notice of it, public doesn't have access to it. So that would be a Bagley-Keene violation. So again, there will be a slide on this, but I think it bears repeating. Avoid emailing each other or calling each other about council business really unless you've cleared it with staff first, because we can keep tabs on what's going on and make sure that, you know, the number doesn't cross, or if it's, you know, if it's an issue that's appropriate to raise to more formal action, we should do that. So always before initiating any conversation, talk to staff, and staff will figure out, you know, the best way to get what needs to be done without violating these rules. And I know it might sound technical at times, but there's really a greater purpose to it, which is making sure that that substantive discussions happen in public. Next slide. This one, you know, for the chair, it's important, and you know, just so you know, there is a whole series of rules that once there is a meeting, which again is anytime 6 or more of you are get together, it needs to be properly noticed. The general rule is that we need to post an agenda 10 days in advance of the meeting. And there are some specific requirements as far as, you know, how much notice and the level of detail that the agendas can give, but none of you really need to worry about that. Next slide. This goes into what I mentioned, that a meeting does not have to occur in one place, that it can include a series of communications, chain of phone calls, email chain, even social media. So again, before having any kind of communications with each other about council business outside of a meeting, talk to staff first. There are some exceptions to the meeting. I won't go through each of these, but essentially, you know, if you guys have independent relationships, social relationships, you're all, you know, you all decide to go to some sort of MCLE, even if it, you know, affects diversity issues, that's fine, as long as you're not getting together 6 or more of you to discuss council business. So this should not affect any pre-existing or new social or professional relationships that you might develop with each other. Bagley-Keene also, sorry, next slide. Thank you. Governs public access to materials distributed at a meeting. So generally materials are actually posted with the agenda. Here in this case, I'm making a PowerPoint presentation, and we did not post that. We often don't, but they are available when we have in-person meetings. We make hard copies, and they're always available upon request. Next slide. Teleconference meetings. There are special rules in the legislation for teleconference meetings, which includes video conference meetings. Some of you who were with us before the pandemic might remember that if you did not come into a state bar location for a meeting, you were required to let us know so that we could post the location at which you were from which you were going to attend a meeting by telephone or video. Under Bagley-Keene, you are allowed to attend by telephone or video, but you must do so, and this is during non-pandemic times, you must do so from a publicly accessible, it's an ADA accessible location. That notice must be posted on the agenda, and it must be open to the public. This particular rule has been suspended, and it's currently suspended until February 1st of 2022. I don't know if there are any plans to extend the governor's emergency order, but under the emergency order, we are allowed to meet remotely without posting any locations. So that's why I'm sitting in my dining room right now without giving the public my address and letting them come in if they want. At some point, it is expected that we will revert to the rule where you need to publicly notice a location. So that could be your office, anywhere there's a conference room. Some people have, you know, been traveling and even noticed Starbucks or a hotel lobby, and 99.9% no member of the public chooses to join you. But that is the law, and you know, maybe it will be modernized at some point to recognize that, you know, most of the public is happy to join in by Zoom or telephone themselves rather than going to where you are. But just be aware, we will advise you if and as this changes for meetings after February 1st.
Brady, we have a question from Sal.
Sure. Sal?
Sorry, Brady, thanks for the education. It's been great so far. You went over the agenda part fairly quickly, but I just had a question. I think you said that not everything we talk about has to be on an agenda. I think that's what it said, or I may have misphrased it. I guess the question I have is, if there's something that's not on the agenda that's brought up by this committee, by this coalition here, we're allowed to talk about it. We just can't take any action on it. Is that correct?
That's technically correct, because the real remedy, unless there's some great willful violation, is that if you meet about something that's not on the agenda and take action, the action is void. So, that's technically correct to stay within the spirit. We don't want to get into big substantive discussions about some topic that's not on the agenda. So that's why we try to, number one, be broad in how we describe, to give ourselves room to have the discussions that we think might come up. Then I've seen it done where, a truly new issue does come up, and we'll say, oh, hey, that's great. Why don't we put that on the next agenda? So,
Sure.
there is some wiggle room, but to follow the spirit, we try and anticipate. And if some major new issue that's truly not part of the agenda comes up, we'll try and give it the attention it deserves on the next agenda.
Okay, thank you.
No problem. See where we were. The next slide is 12, teleconference meetings continued. So again, this won't come up until at least February 1st. But the rules on teleconference meetings are pretty clear and strong. Again, maybe they'll change given the success of Zoom meetings over the past 2 years. But it has come up that somebody's unable to notice the meeting to provide us 10 days in advance with a location from which they will be calling in or video conferencing in. And in that case, the council member may listen if they want to, but they can't participate if they haven't noticed a meeting. That's under the non-pandemic rules. And again, we will advise you of those rules if and when they go back into effect. Next, slide 13 is on public comment. Sorry, I didn't join in at the beginning, but I'm assuming you already had a public comment period. Mm-hmm. Those are required by the Bagley-Keene Act. An opportunity must be provided for members of the public to directly address a public body on each agenda item, either before or during the consideration of the item. Generally, we have public comment at once at the beginning of the meeting, which is allowed. And we are allowed to make reasonable regulations, including limiting time for particular issues or individual speakers. Our standard is to generally announce that depending on the number of people in the agenda, that 2 or 3 minutes are allowed per person. But if there's ever a huge number of public comments, you're also allowed to put a total limit on public comment. Next slide. Again, I mentioned this earlier, but social media is also a communication. So, we definitely encourage people, to the extent they use social media, to share State Bar news. You can't speak for the State Bar, but you have your First Amendment rights to comment on anything, and you can also, share items from the official State Bar social media accounts. We encourage that, but avoid getting into discussions about council business, because those can very quickly involve lots and lots of people. Next slide. Remedies and enforcement. The key one, and this does happen. It hasn't happened at the State Bar during my since we first became subject to Bagley-Keene, but I have definitely heard of it happening in other areas of the state government, that decisions or actions can be overturned if they occurred in violation of Bagley-Keene. To me, at least, the greatest remedy and enforcement is the court of public opinion. We are a public institution, and we want the public's trust, and we need to earn that, so that we should follow our rules. There is also the possibility of civil action and fees and fines and even a criminal action for willful violations. So this is serious, but those are, as you might expect, very rare. Next, California Public Records Act. Next slide. I don't think we need to go into the history of it, but in January 1st of 2016, State Bar became subject to the Public Records Act. And that creates a presumptive right of access to any record created or maintained by the State Bar or other public agencies that relates in any way to the business of the State Bar. And the way that it works, let's go to the basics, next slide. Public record is really just about anything, and there are exceptions for privacy, human resources type documents. But in general, the substantive work of the state government, including the State Bar, takes the form of public records, and any person, anybody, can request a public record. And really all they need to do, we have a process on the website, but they just send us an email describing what they want, and there are rules that we need to follow to get that to them. Some crossover, next slide, on Bagley-Keene. Public records include, everything that we distribute to you, with the exception of what might happen under closed session, although closed session for COAF is exceedingly rare. And any audio or video recordings of the open meeting that are made are also subject to public disclosure. And in fact, we generally post those affirmatively. Next slide. So I think where this affects you guys is that email communications may be publicly disclosable. If we get a public records request about your communications on COAF business, we will need to respond to that unless there's, I give you guys legal advice, there would be a privilege exception. But the reason we want you to know about this is, number one, to just be aware that emails that you send could end up in the public eye. It's always a good thing to remember when you're writing them. And also, in the event we do get a public records request, we would like to help you keep that as free of burden to yourselves as possible. So the way to do that, and again, this will help us help you avoid Bagley-Keene violations, is on any email, even between yourselves, to always copy State Bar staff, because that way we have copies of all of your documents that involve council business. And to the extent we get a CPRA request, if you've been doing that, we don't need to tell you to go search your emails, because you can tell us, oh, I've copied you on everything. And then we can go through it ourselves.
Brady, Stephanie has a question.
Sure.
Yeah, hi, Brady. I think you sort of touched on it. So obviously, if the CPRA request involves, let's say, an email that is specific to me, I would be notified of it because you need to obtain it for the requester. But what about just general requests for more public documents related to COAF? Would we be noticed, or do you guys just take care of it?
Elizabeth, do you have sort of a there's no law that requires us to, but I would imagine that that we do notify people if we're going to be using your emails, certainly.
Correct. Yeah. I mean, if
as a matter of
courtesy, we would notify you if we were distributing anything that you would be involved in.
Oh, thank you.
Next slide. So just to sum it up, a few tips for compliance. Be careful when emailing or texting about State Bar business. This may later be deemed a public record. And again, make sure that as best practice, you copy State Bar staff and before you engage in communications with each other to help avoid Bagley-Keene violations, either route it directly through staff or make sure that we're aware of what communications you're going to have and with whom. Avoid conducting conversations about council business outside of a noticed meeting. And when in doubt, again, route communications to State Bar staff only, and we can distribute it or figure out how to do it in a compliant manner. This I'll sort of leave to your best practice, but a suggestion is to keep your emails regarding State Bar business separate from personal emails using a folder. But again, the best way to avoid any burdensome need to comply with a CPRA request is to make sure that we're copied on any of your COAF business. So then it's a matter of us telling you, hey, we've got a request that's going to touch on your emails. I think we've got them all because you copied us. Let us know if you haven't copied us on anything.
And Helica has a question, Brady. Sorry.
I don't know if you're going to touch on this, but just do you have general guidance on the length of retention of any of the emails?
So State Bar, we actually we do backups and we retain for years and years. So we don't have any real destruction policy. So as long as you're copying us, that's, we'll have it. As far as how you do, there's no requirement. So just follow your usual practice. Obviously comply with requests from State Bar staff. If we have any for you, again, hopefully we won't or we'll have everything. And if you ever have any questions, that's what Elizabeth and I are here for. Any other questions before we switch to Prop 209?
Do we have any questions?
So I'm sorry if I'm making anybody dizzy with my holding my iPhone with the camera in one hand while I'm trying to work my my unconnected to the internet computer here. All right, let's move on to 209, the 209 slideshow.
Okay.
So I thought before last year's election, we might not be giving this training anymore because repealing Prop 209 was put before the voters last November, but that effort did not succeed. So here we are. Proposition 209, let's go to the first slide, is a provision of the California Constitution that limits California government agencies' ability to consider race and other categories in 3 areas: hiring, contracting, and education. It was passed in 1996, and it's codified at Article 1, Section 31 of the California Constitution. And in relevant part, it provides the state shall not discriminate against or grant preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or national origin in the operation of public employment, public education, or public contracting. Next slide. So Prop 209 is only implicated when the state government, including the State Bar, is operating public employment, public education, or public contracting. So in practice, that means that Prop 209 is not implicated by many COAF activities. However, typo there, Prop 209 may be relevant when COAF considers policies and practices of state agencies, including the State Bar. In the past, COAF has provided valuable advice on State Bar hiring practices, including how we hire the people who, for example, grade the bar exam. So when we look at those issues, we do need to be cognizant of Prop 209. Again, as it says here on the slide, Prop 209 issues have been most often relevant to COAF in the context of public employment. Next slide. Oh, sorry, that's a perfect slide. In public hiring, Proposition 209 prohibits discrimination against or preferential treatment of anyone on the basis of race, sex, color, ethnicity, or national origin. For Proposition 209 purposes, to discriminate means to make distinctions in treatment, to show partiality in favor of or prejudice against a particular candidate or group of candidates or employees. Preferential treatment means giving preference, which is giving of priority or advantage to one person or group of persons over others. Next slide. So Proposition 209 applies to differential treatment of both members of a majority group and members of underrepresented groups. The Supreme Court found that the voters' intention in enacting Prop 209 expressly included reducing, quote, reverse discrimination based on race or gender. Unlike the equal protection clauses of the federal and California constitutions, Proposition 209 absolutely prohibits race-based discrimination and preferential treatment. It can't even be justified even by a compelling governmental interest. So it's not quite such a straitjacket as it sounds. Courts do recognize a distinction between impermissible activity that advantage one group over another and permissible activities that aim to broaden access for all. One key case was in 2000. In there, the court struck down San Jose rules requiring city contractors to either meet a quota for use of minority and women-owned subcontractors or to provide such subcontractors with special notice and procedural rights in the bidding process that others did not get. But the court, in making that decision, recognized that outreach designed to broaden recruitment for public employment activities, is permissible. The court said plainly the voters intended to preserve outreach efforts to disseminate information about public employment, not predicated on an impermissible classification. Next slide. Further court guidance regarding impermissible discrimination and preference versus permissible outreach came in the Connerly case in 2001. And they provided some examples of what sort of outreach, recruitment, and hiring practices are permissible under Proposition 209. So affirmative action programs imposing specific goals and timelines for hiring members of any group are impermissible. Outreach efforts that provide special notice only to certain applicants are impermissible if based on race, sex, color, ethnicity, or national origin. But outreach efforts designed to broaden the pool of applicants are permissible. So, one applicant for a job doesn't have any constitutionally interest in, limiting others from getting notice and the same opportunities to compete that they do. Next slide. One area of note is that research and analysis regarding employment of underrepresented groups is permissible. So it doesn't impact at all our data collection analysis or First Amendment rights as a group to speak out on these issues. Next slide. Race and gender neutral policies promoting fairness and diversity may be permissible so long as the criteria used are not a proxy for race. So, a diverse recruitment pool, may be promoted by targeting recruiting and hiring activities across diverse geographic areas, diverse educational settings, diverse practice areas. Next slide. And on the next slide, we already went through the impermissible activities. Let's go to the permissible activity slide. So, some examples of ways to increase diversity in hiring pools and ultimately in hiring include outreach to increase applicant pools. That could include posting job opportunities with minority and specialty bar associations, provided that you're still giving information broadly. Also, Proposition 209 does not prohibit the state bar or any other state agency from activities such as participating in diversity and minority job fairs, provided that those fairs do not actually exclude anybody on the basis of enumerated characteristics such as race, gender, national origin, and provided that the state bar or whichever government agency we're talking about also participates in job fairs aimed at broader populations. So in other words, you can do targeted outreach as long as you're still doing broad outreach. Also permissible is targeting outreach to underrepresented schools and geographic areas that are underrepresented in the applicant pool, because schools and geographic areas are not impermissible classifications under the proposition. Advertising and distributing the State Bar's missions and its diversity policies and activities, including COAF's work, is certainly permissible. Using diverse hiring and interview panels is permissible. Eliminating barriers to hiring, including job criteria that may disproportionately impact underrepresented groups while having no or limited relevance to job performance, and all sorts of initiatives to combat implicit bias. Those are all certainly permissible under Proposition 209. Also permissible is things like creating hiring guidelines and interview questions that value diverse skills and experiences, so long as the criteria are relevant to the position. Those can include factors such as foreign language ability, demonstrated commitment to valuing diversity, such as experience increasing access to the legal system for underserved groups, experience working in diverse workplaces or serving diverse populations, demonstrated resilience in the face of adversity. These are all things that we can look at in hiring and recruitment that are obviously supportive of diversity without actually making decisions on an impermissible basis. Next slide. Also permissible, activities and programs to reduce unconscious bias and in-group favoritism, including trainings. Monitoring and analysis of female and minority involvement and success in recruiting and hiring. Again, that returns to the point that analysis and information gathering and even advocacy on these issues is permitted. And finally, as we do, consistent with the Civil Rights Act and the Fair Employment and Housing Act, ensuring a diverse, discrimination-free workplace, which in itself hopefully promotes retention of a diverse staff. So, Proposition 209 is what it is, and it definitely imposes some limitations on what we can do as a public employer. But within that framework, there is still a lot that's left to be done. So I'm happy to take any questions or comments on this. And again, where we're working with pipeline issues involving private employers, this doesn't come up at all, but it's more when we're looking at the State Bar's own practices and other government agencies.
Thank you, Brady. Does anyone have any questions, comments, or considerations for discussion? All right, thank you for the presentation, Brady. We appreciate it, very informative. And Elizabeth, what should we do next?
We have our update on the reforms for the attorney discipline system. So Lisa and Kelsey are here.
Okay.
So we're back on track, Ryan.
All right, and this is item 5B on the agenda.
Sorry.
Yeah, go ahead.
Okay, hi, good morning, everyone. My name is Lisa Chavez. I'm the director of Araya, and I'm here with a new principal analyst in Araya named Kelsey Lyles. Kelsey Lyles comes to us from the Green Lining Institute, and she's going to be taking the lead on all of our racial disparities work. So together, she and I are going to give you a presentation on where things are at. So I'm going to go ahead and share my screen and get started. I'm really going to focus my comments today on two issues. One is an update from how the ad hoc commission on the discipline system, where their work is right now, in particular, how they are really honing in and their working groups on efforts to address racial disparities in the discipline system. And then next we'll talk about where the State Bar is with regards to the projects on increasing attorney representation per Professor Robertson's recommendations. Oops, let's get started. So we have a few COAF members who are part of our ad hoc commission on the discipline system. So hopefully at some point, please feel free to chime in. So just as a reminder, we have our ad hoc commission that had split out into two subgroups, one that really honed in on the issues of fairness and the others issued of effectiveness. And they shared their findings with the broader group in September, and then they split into a series of working groups where each working group takes on a specific topic that they're gonna go really deep on for the purpose of developing recommendations.
And so they're doing that work right now. And then they're going to have the whole group will come back together in spring to discuss those recommendations. They'll adopt recommendations in May, and they'll have issue their final report to the Board of Trustees this summer. So what I'm going to do right now is, so we have around at least 7 working groups, and a few of them are really focusing on issues of fairness that are of interest of this group, how to address fairness in the discipline system. And I'm going to share, give you a little flavor of the types of questions that they're asking and the type of data requests that they've made. So one working group is really honing in on the issue of expungement, and they're looking at expungement in 2 different ways. One is they're taking a really hard look at the fact that if you go to our attorney profiles at the State Bar website, you will see an attorney's entire disciplinary history, as well as any consumer alerts that State Bar has made available to the public. And they received some interesting public comments on, such as like, hey, you know what, I was disciplined 10 years ago and it's still kind of haunting me, you know, like someone does a little search on my name and they say that shows that I was disciplined 15 years ago, 10 years ago. This really isn't fair. So they're looking at that, what would be involved in expunging information that's on the website. And they're also looking at what would it take and what does it mean to expunge post-conviction discipline from an attorney's record. So these are the types of questions that they're asking. So they're saying, how can expungement address racial disparities? They're also asking what other professions do, or whether they're licensed profession, like what does the medical board do? What does the nursing board do here in the state of California? What do other states do? And so staff is gathering all this information to help with their deliberations. Then they're asking questions such as, I mean, they're really going to make some recommendations, like, so what type should expungement of certain disciplines be automatic, or should it be like, and if so, after how many years, or should it be a situation where someone has to apply for it to become expunged? And then another thing is they're considering is, should certain misconduct be excluded from expungement? So here they're taking their cues from like recent changes in the criminal system here in California, where we do have expungement opportunities, but certain crimes are excluded from that. So this is an example of the types of questions that the expungement working group is working on. Another working group is looking into diversion, and this is the State Bar's alternatives to discipline that we have. And again, you know, remember Professor Robertson, Professor Farkas, you know, found racial disparities in discipline. So the reason why this group is looking at this is to understand, well, if there's racial disparities in discipline, to what extent is this, or do the few alternatives to discipline that the State Bar does have, how effective they are, and how is equal representation in participation. So the 2 diversion programs, we have 2 broad categories of diversion. One is the alternative discipline program, and this is really available to attorneys who have mental health and substance abuse problems. And then we also have other alternatives that OCTC can tap into. One is like an agreement in lieu of discipline, so it's like early on in the process. They also have the opportunity to send someone a warning letter or a resource letter instead of receiving discipline and having an investigation open against them. And again, the staff is generating analyses like how effective these are at preventing recidivism, and is there any racial ethnic variation in participation and access to these different diversion programs. Another working group is looking at discipline costs. And so there's 2 types of costs that attorneys incur during the discipline process. One is that there's costs associated going through the process. So depending on how far someone's case goes into the process, they will incur a set of fees. And this committee learned that the really biggest increment is in between a 1-day trial and a multi-day trial. So if an attorney's case ends at a 1-day trial in state court, they're levied $8,000. If they have a multi-day trial, really just more than 1 day, those costs go up to $19,000. So this is a really big concern to the group because they're asked, and then also there's monetary sanctions involved with discipline. So they're really asking the hard question. First and foremost, are these costs fair? Because perhaps respondents might feel pressure to settle or to keep their trials brief. And so these are the types of questions they're asking. They're also asking information such as, out of all the costs that are generated and revenue collected by the State Bar, how much of this is actually collected, how much of this is impacting people from practicing, and how much of these costs comprise the entire State Bar court budget. So in other words, if we got rid of these costs, would the State Bar court go away, or how much, to what extent is the court really dependent on these costs? So that's what this working group is looking at. And then finally, another group is looking at the complaints closed without discipline. And as you may recall from Professor Robertson's report, he recommended that the State Bar expunge cases that are closed without discipline. But instead, the Board of Trustees directed staff to simply shield cases closed without discipline from staff view after 5 years. And the reason why this is just an important issue for this working group is that the Professor Farkas's finding, which is that Black male attorneys are more likely to have complaints closed without discipline. And the number of more complaints you have closed without discipline is actually a big predictor of discipline in the future. And so this working group, is really thinking hard about the fact that the State Bar does not alert attorneys of the fact that they received a complaint that was closed without discipline. We did an analysis of other states, and we found out that 13 other states actually do notify respondents that they received a complaint that it was closed without discipline. And that it was so this group is asking, like, what are the pros and cons of at least alerting attorneys that you may have some clients that are dissatisfied with you may want to work on this and that, even though you're not opening investigation. Here's something to consider. You received a complaint. So this group is thinking in terms of, like, maybe it'll be after one complaint, after 3 complaints, several complaints of the same type. So the staff is doing a lot of analyses that address this issue to help them make this decision, because this is just, I think that there's research that showed that other states do this. Then the question, why doesn't the State Bar do this? And there's lots of, I think the tricky thing is that we actually have massive volume of complaints coming in compared to other states. And so we're sharing that information as well. And we're also gathering information of, like, what type of staff resources would it take to notify people of complaints closed without discipline. So this is just like a little flavor of the types of questions of the different working groups are working on. Does anyone have any questions about this before we go talk about attorney representation?
I have a quick question. If no one else does. Sorry. Thanks for this presentation. Is it okay to go ahead? Ryan, is it all right?
Yes, go ahead. And Heather has her hand raised too. Next.
Okay. Okay. Lisa, thanks very much for the information. 2 things. One is, I suspect you have information about Hispanic and Asian attorneys as well, that would be part of a report somewhere. That's the first part. The second part is, I'm curious on, with respect to the trial costs, I know that that's the award that's given to the state if or the sanction that's given to the attorney should it go adverse to them. But I'm wondering if there's some school of thought, or you already do this, where you have the attorneys that are going through trials who decided to go through trial to put that money into an escrow, so that it would offset some of the costs of the trial, and also really bring the parties to some sort of an agreement sooner rather than later, so that so that the attorney, not to make it punitive, I don't mean it that way, but just to have the money in escrow, so that if the attorney wins the event, then the money gets back to them with interest. But if they lose it, it's already there. So it's it's something the state can attach quickly.
I'll make a note of that. Thanks.
All right, Heather.
Thank you, Lisa. That was really great. I wanted to know if you could give us some more insight about the decision to not expunge the complaints that were closed without discipline, but instead to just shield staff access to them for after 5 years. I just wanted some more information about how we came to that determination, because that still feels like a big gap between ways to solve for that.
And when I was started to do this work, I went back and reviewed the Board of Trustees, by the way, is the one to make the decision. They looked at Professor Robertson's recommendations, and he gave two recommendations, actually. One is to shield after, I think it was like 1 year, or expunge after 5 years. And so what they came up with was like a hybrid, like a shield after 5 years or something like that. That's what it was. But when I reviewed the recording, I don't recall them saying the reason why. So maybe the one thing I can think of is that they just saw he had two recommendations, and they just landed on one that looked like a hybrid, like a middle ground.
But I feel like the hybrid is more harmful, because if you expunged after 5 years, it would be permanently gone. And so the longer term kind of makes more sense because it's gone. If you shielded after 1 year, that would prevent bias faster, because people, after a year, people wouldn't be able to see that. But now they can see it for up to 5 years, which allows for bias, and you still don't get expungement. So I feel like in compromising, they actually made it more problematic. So
if I may, Lisa, I think there were a couple of reasons behind it, and I'm sort of recollecting back to the time. One is, I think there are record retention requirements that we have that don't let us just expunge those cases. The other is more of a substantive reason. And to be clear, the archiving, in order to get access to be able to, the people who are doing this on a routine basis, who are looking at the new complaints, do not have day-to-day access to the information. They would have to do a request to the supervisor in order to be able to look at anything older. But one of the concerns I think that the Office of Chief Trial Counsel had raised is that, one benefit of having access to older information is pattern detection, identifying sort of a pattern of behavior over time that is that sort of one case one complaint in and of itself doesn't sort of raise a red flag. But if there's sort of a history of this over a period of time, that could raise a red flag. And the board said, okay, let's basically say, yeah, history over 5 years is fine for you to look at, and you don't need to go sort of further back than that. But there sort of was the sort of thinking about, well, in the rare case, what if we do need to look further back to identify sort of a pattern of behavior? And so but there's very limited access to it. The people who are reviewing the complaints that come in only have access by presenting a case to a supervisor on why access is needed to any of the older complaints. And again, right, these are all complaints that were closed without discipline, because on their own they did not merit. It was determined that they did not merit discipline. And so we did our best to really structure the access to very limited circumstances, so that as a general rule, people are not looking at those older cases, because we know that complaints come in at a higher rate against attorneys of color.
that was my point, Donna. Yeah, I totally understood that it was about, determining if there was a pattern in practice, but that's also what leans into bias, right? And if you have frequency of touch, which I know you recall, we talked about, 2 years ago or something when we started looking into this, then inevitably there's going to just be more of those types of complaints. So I really would like to emphasize that we should have strict scrutiny around who gets to access, those previous records, because I just feel like it cuts both ways. Certainly we want to make sure if there's something going on with someone, we're keeping an eye on it, but we don't want to lean into a bias in that space. So.
Judge Kristen.
Thanks, Ryan. And thank you, Lisa and Kelsey, for that. Heather asked one of my questions about how we made that decision for the 5 years. And the other question I had, Lisa, and maybe you know the answer, because I'm intrigued by Sal's idea of the escrow account. I'm wondering if you have a sense of how long it takes from complaint to decision from the state bar court. Are we talking, a year-long process, or are we talking something faster?
I think it varies depending on, I'm sorry, I don't know. I mean, because cases close at different stages. And so I imagine, I'm sorry, I don't know off the top of my head how long it takes the case to close that makes it all the way up to state bar court.
Yeah, and
Okay.
our general, the current general goal is that, you know, cases would be closed for lack of stating a claim that rises to the level of clear and convincing evidence of misconduct, or forwarded to the state bar court, or stipulate for with a notice of disciplinary charges or a stipulation entered into in 180 days. And then once filed with the state bar court has a timeline as well. That I believe, depending on the case type, again, assuming it's contested and not a default, but if it sort of goes through from the filing to the end, I believe that timeline could cap out at about 235 days.
Okay.
I'm not sure why that number sticks in my head, but I'm visualizing a PowerPoint chart that I've seen.
Okay. Okay. And my last question has to do with the monetary part that the discipline costs working group is looking at. The one-day trial is $8,000, and then the monetary sanctions, should you be found in violation, or added on to that, right? Okay.
I think so, yes.
Okay. Okay.
All right, Sal.
Yeah, thanks, Ryan. And thanks again, Lisa and Kelsey, for all the hard work. I just looking at it from the other side, that there's a great number of attorneys or so-called attorneys in the state that prey on the Spanish-speaking community, especially in the areas of immigration, criminal law, and those kinds of areas. I'm just curious, looking at it from the other side of the lens, is it your group or is it a different group that looks at how with what ease can a member of the Spanish-speaking population file a complaint? Because there's a lot of attorneys who go years preying on the community before anyone finds out. It's usually after they have victimized many folks in the community. So I'm just curious from your end, is it your group, Lisa and Kelsey, or is it a different group? And what is the status of it if it is your group?
So the ad hoc commission on the discipline, they heard a very comprehensive presentation in spring on all of the initiatives and the policy changes, work that OCTC has implemented in the last 5 or 6 years. And they did receive, and with the goal of like, listening to everything, making decisions of what they'd like to hone in on. They did hear a presentation on this particular unit that deals with exactly the type of misconduct you're describing. And I believe that their conclusion was that they were satisfied with the work that was getting done. And so they did not make a decision to, kind of go deeper into that. But I think it's just some more information about like that, because it's actually a very specific unit with an OCTC that deals with exactly what you're describing.
Thank you.
Thanks, Sal. Sarah?
Hi there. I'm actually participating on the ad hoc commission, and I'm in the fairness section. And then I'm on a bunch of working groups, primarily expungement and the closed complaints. And then under expungement, there's like subgroups, like I'm progressive discipline, and I'm chairing that little subgroup. So there's a lot of work going on here. And one thing I just wanted to emphasize, which Lisa mentioned, which is the state bar did adopt some changes initially in response to the Farkas report, but everything is on the table for review by the ad hoc commission, including the initial changes that the state bar did and whether or not those were sufficient. So I just wanted to sort of emphasize that, really in response to Heather's question of some minutes ago, just so that that was clear. But there's lots of work being done here, lots of meetings open to the public. I have a huge binder of materials. So there's you know, a lot of really deep thinking going on with the use of experts, particularly the Farkas report and everything else. If anybody else wants to take a deep dive, there's lots there. Thanks.
I feel in good hands now, Sarah. Thank you.
Thanks, Sarah. I would also like to add a couple comments, and I have a question for Lisa or anyone else if Lisa can answer it, because it doesn't fall squarely into the work of the ad hoc commission, but it does fall squarely under the update on efforts to reform the attorney discipline system. So at our last meeting, we talked about an issue that I had raised pertaining to enforcement of Rule 8.4, which addresses discrimination in the legal practice, specifically with respect to senior manager attorneys discriminating against younger attorneys in a law firm and decisions to hire or promote or pay or anything related to the workplace. And that rule also covers attorneys discriminating against their clients as well. I asked for our Office of General Counsel to speak to whether or not they are adequately enforcing this rule. And we had folks from our trial team office talk about how the rule is relatively new and they have some cases in the pipeline, and they are looking to continue to enforce this rule and have the state bar adjudicate these violations of these cases or of this rule for certain attorneys in the state of California. And another one of the comments I had was, could we kind of publicize this rule more so more attorneys know about it, so potential victims could know it exists and file complaints with the state bar. And the conclusion on that was that yes, the state bar would create a like a notice or a publication about this rule, and I offered to help with that. And so I was wondering, where are we with creating like some type of public notice for this Rule 8.4 and our state bar's commitment to enforce it?
Ryan, in terms of the notice to all attorneys, I believe we are planning to put a notice in the next all attorney email. It's a quarterly email that goes out to all attorneys. So yeah, I know that that's planned. I'm not exactly sure what the schedule is for the next email. I don't know, Donna, if you know off the top of your head.
I don't actually. I think one went out. I'm sorry. I'm checking my Gmail because that's where I get those. I think one actually went out this past week. So I hadn't had the opportunity to review it yet to see if it's in that one. I think it's not. I think it's planned for the follow-up one. And so if one just went out, it would be the next quarter.
Okay, thanks. And I still would like to extend my offers to help with that in case you need me, because I definitely would like to see it kind of jump off the page so folks continue to raise awareness about it.
Yes, absolutely. We appreciate that offer. And again, I just found the email, so I'm just searching through it. And we'll absolutely share with you what we compile to get your input on that before we send it out, without question.
Thanks. All right, do we have anyone else that has comments, questions, suggestions? Seeing and hearing no hands, I will go ahead and move on to the next item on the agenda.
Ryan, Lisa's not done.
Oh, I'm sorry. Yeah.
So now we're going to change gears and give you an update on the State Bar's work on attorney representation. Before I do that, I just want to make a note that the Ad Hoc Commission on the Discipline System does not have a working group on attorney representation, because I believe it's because they're convinced that the State Bar already has a very robust plan in place that were different streams of work. And so I believe that was the reason why there isn't a working group. And so anyway, so we're giving you an update on that work right now. Okay. And we also give updates to the ad hoc commission as well. Like our plan is to give them an update in spring. So here we go. So update on attorney representation. So let's, I always like to give this, discuss this work in the context of Professor Robertson's recommendations. And so what I'd like to do is just methodically go through each recommendation and give you a status of where things are. So he recommended that the State Bar start informing attorneys who are facing discipline about the increased likelihood of being disciplined if they didn't secure counsel. So as we've shared in the past, we started distributing a letter almost a year now to attorneys facing discipline. That is, if they had an investigation opened against them. And so we've been distributing that letter for about a year, and we purposely made a decision to distribute it to only half of all attorneys who are facing discipline so that we can kind of like doing like creating a control group. And so the goal is in Q1 of next year to really try to understand if this letter had an impact in increasing representation among the attorneys that did receive that letter. So I just want to give you an update on that, because that analysis is planned to be done in Q1, with the goal that once we understand if this letter had an impact or not, we can make adjustments to the letter, because of course the goal is ultimately to start distributing this letter to all attorneys who have an investigation open against them. So that's the status on this. Another recommendation Professor Robertson made was for the State Bar to start tracking the percent of discipline cases who have here it's like lacking representation, but actually we're tracking a percent of attorneys who have a case closed in investigation or higher that had representation. And so this is the data that we've collected on this so far. And this is actually another possible measure of the impact of the letter. As you can see, we started distributing it in Q4 of last year. But what's interesting is that before we started distributing it, there was actually a steady increase in the percent of attorneys who were securing counsel as they were under investigation and under discipline proceedings. And as you can see, it's been over 20% throughout this year. So this is just a metric that, like I said, he recommended that we start tracking, and we've been doing so. We share this data with the Board of Trustees regularly. Okay, so now I'm going to turn it over to Kelsey, who's taking the lead on Professor Robertson's two recommended reforms with regards to working with the ADDC on offering pro bono consultations and how we can give this representation to attorneys who need it based on a sliding fee scale. So go ahead, Kelsey.
Thank you, Lisa. Thanks, Lisa, and it's nice to meet you all. Look forward to getting to know you. This proposal is in the very early brainstorming and preliminary phases, but essentially to continue to increase attorney representation. The idea is that the State Bar would partner with ADDC and provide some subsidized funding to participating attorneys that would provide free and also reduced cost legal services. So specifically free phone screenings, as well as case evaluation, and then low bono representation. As far as eligibility, initially we're thinking that attorneys who pay reduced State Bar licensing fees would first be eligible. And we would actually advertise this pilot program through the resource letter that Lisa was just describing earlier. So as far as next steps with this, we are still in the early stages of figuring out the details, how to actually administer a program like this, and some of the key decision points, and how to subsidize cost for some of the participating attorneys. We also still are in the process of building that relationship with ADDC. We'll want to get their feedback soon. And then once the proposal is further along, we would like to bring it to the ad hoc commission for their review. And from there, actually bring that proposal to the Board of Trustees with a $250,000 budget request. Lisa, did you want to add anything to that?
Right now we're thinking in terms of $250,000 for a one-year pilot program, in which case we will evaluate its effectiveness, etc. So does anyone have any questions about the progress on this case?
Judge Kristen has her hand raised.
Okay, go ahead.
Thank you, Kelsey, for that. I have just a quick question. When we're talking about the eligibility, do we have a sense of what percentage of attorneys being disciplined fall into this category of folks who are paying reduced state bar fees?
I know we did this analysis at some point, but I'm sorry, I can't recall. I don't know it off the top of my head.
That was my question, Ryan.
All right, thanks, Judge Kristen. Does anyone else have any questions? All right, Lisa, thank you for your presentation. Do you have any other presentations for us today?
No, we do not.
All right, thank you so much.
All right, thank you. See you next time.
See you later. All right, so next on the agenda, I see we're in section 8 now, subsection B, having to do with institutionalized diversity and inclusion goals in the bar exam, question and development, and grading. And it says here that Shalak and Heather will lead us in a discussion on the DIF working groups activities.
Thank you all. Hi, everyone. So yes, Sal and Shalak and I are the COAF members who have been participating in the DIF subcommittee, examining the bar exam question development and grading processes. And so if we can go to the next slide. We have been meeting regularly over the last few months to evaluate the current bar exam questions. We started off, as many of you may recall, and for the new people, maybe almost a year ago, looking at the processes around how we select graders and how we go about grading the bar exam. And now we've been doing a deep dive into the questions themselves. So we actually evaluated many of the former questions, looking to see if we saw bias among the questions, including looking at principles around the verbiage and terminology that have common meaning or might be unfamiliar or uncommon instead, trying to find greater gender balance in the fact patterns, making sure we strive for balanced representation across gender, culture, and ethnic groups, avoiding cultural references or expressions that aren't familiar to test takers, and minimizing fact patterns that might trigger traumatic or emotional responses. And I want to say it was much more challenging than I would have ever expected it to be. When we started on this road, I thought it's going to be so blatant and clear to us that, like, wow, we're using language or formulating questions that are really problematic. But it really took some deep analysis in some areas to evaluate kind of how nuanced it was. It was much more nuanced than I expected it to be. So if we can go to the next slide. Our latest position in this is that we met on the 29th to go through the set of guiding principles to be provided to the drafters to help shape how they could prevent future bias in exam question development based on what we identified in the patterns of bias in the exam questions that we evaluated. And so now that group will go back for January and fine tune those guiding principles based on the feedback that we gave to them so that they can present those to the Board of Trustees for approval. Any questions for me or Sal or Shalak?
I was just curious, did you find any kind of egregious examples or did you really have to unpeel the onion to get to the point?
There was not, there were some things that everybody did it in their own bubble, right? So to ensure that we were, totally unbiased in our analysis of it. And then after we filled out a grid of, I think I saw these types of issues or types of bias in a question, then that was all collected to see if repeatedly each of us had seen something. And so that's where you started to uncover some of the patterns. Like if everybody saw that there was an issue with gender or a triggering kind of biased issue, then it was like, oh, it's not just me. But it wasn't so blatant on the page necessarily that I, some of the questions I was like, this hints, I would have worded it differently. I think if you framed it just slightly differently, you'd get a different impact. And I think when we all finally got to get together to discuss our responses to it, everyone felt similarly. It wasn't like, oh my God, you could see why there was bias in this question. It was that blatant, but all of us had picked up on the same nuance. So it was not subtle enough that it wasn't detectable. So and Shalak, Sal, please feel free to chime in.
I was just going to, yeah, Heather, thank you for that. It was wonderful. And it's been a pleasure working with Shalak and Heather because they're not just great people, but we've all kind of had the same intent of we're gonna get rid of the bias. But like Heather said, it's really hard to see it. And Ryan, to your question, one of the things that's interesting about it is that if you read it right away, we are, the three of us were looking for bias. That was our intent of the question was, let's find the bias, let's get rid of it. But if you put yourself into the shoes, obviously, of a law student, of a graduate law student, they're going to answer the question based on the first impression they get. And therein lies the problem, is that the first impression they get is the assumption they make or whatever stereotype was given, they're going to play on that. So, this is why this is why the work we do here is so important, folks, because the more we eliminate for that, the more we're leveling the playing field.
And like some of the nuance and subtlety, Ryan, for instance, was around issues around domestic violence. Like, is it always the man that's the initiator of domestic violence, or is it always in certain communities, or so there were like triggering issues that also might have had some nuance. But part of what we talked about, even in the substance of the question, if you're testing on a particular substantive legal issue, there are going to be some things that you have to include. And so as we gave feedback on the guiding principles, we tried to keep a balance of all of that in mind. So I see Michael has his hands up.
Oh, I'm sorry. Go ahead, Michael.
I just wanted to ask, thank you for all of this. This is, I think, really an interesting and important issue. I'm wondering whether there's a mechanism probably already in place for test takers to report problematic questions or problematic issues after they've taken the exam, because I think I've blocked out. I don't remember much about taking the bar, but I suspect that folks that have just gone through it would be a good way to hear about, while it's still fresh, issues that we could spot in the future as well.
To my recollection, nothing like that was discussed in our working group, but perhaps it's something that we could raise to that working group the next time we meet. I think, that could be worthwhile. I will say, as someone who takes challenges from law students about their exams pretty frequently, it's sometimes hard to distinguish what's the I didn't study for this, or I didn't think it was fair part, and what's the there was bias in this. So sometimes having, I think even 6 months or a year removed can remove did I find bias because I think I'm gonna fail, versus did I find bias because there may or may not have been some there. I was also just going to comment that I think part of what's been interesting, as Heather and Sal shared, so not to repeat too much, but is also the context of the different types of assumptions we make. So to the point of our public commenter on representations about disability or native language or rural versus city living and so on, and being intentional about looking for some of that bias in the questions that may exist, and what types of information we assume people will have about the size of lanes in a highway, or how many lanes are there, or what it means to drive a Jeep or a truck versus a small 2-door car, right? And so how some of that plays in was very interesting to look at. And I think, as Sal was saying, sort of feeds on the assumptions that people bring in automatically.
So if I could add, I thought that was it's a really interesting suggestion, Michael. And I think, right, one of the ideas here is this is a huge endeavor, doing this analysis, coming up with these guidelines, but it needs to be a living document, a living process. And so one of the things that the State Bar instituted with the remote, when we switched to the remote exams, was doing a post-exam survey, asking about the conditions, et cetera, that would give us some insight. And so, I can certainly see us morphing that kind of survey to asking these questions, making it clear this is not an opportunity to complain about anybody's grades or I performed badly on X, Y, or Z, but that this is a continuous learning process for us to make sure that we that we remain very attuned to these issues. And so anything that they can highlight that would cause us to update our guidelines, sort of rethink things. I'm pretty intrigued by that suggestion, Michael.
I am too. And I think as we think about just creating better exams in general, not just for the purposes of COAF, but some of the other things that we all identified as we were looking through, if there was a question that was just like, is there anything that was concerning or confusing to you about the exam itself, it might capture that. And if 50% of the test takers say this particular thing was really confusing to me, because part of what we talked about just as ancillary to it is if you get caught up in what seems like a red herring or some undefined term that you're unfamiliar with, and now you've lost 15 minutes of time and it wasn't integral to the question anyway, like that's something I think just as drafters, we want the team to know, like, oh, we didn't intend for that to be, problematic, but so many people had a concern with it. So agree, Donna, if there's a way to neutrally capture it so that people don't use it as an opportunity to complain about, yes, and that's why I didn't pass it because it was, but really capture so that we can just keep refining in a consistent way, the way we approach the exams.
Right. There's, this discussion kind of has created within me like a new area of thinking when it comes to questions that kind of present a issue of diversity and representation. For example, it was my general assumption or understanding that when you have like kind of tone deaf questions, someone from a diverse background from a different perspective might get the question wrong because they're looking at it differently and they're interpreting it differently. But then there's another thing that kind of I think really makes me realize it from the discussion we're having today is sometimes questions can be triggering. They could cause you to expend emotional and mental resources because they upset you. Like, for example, a question where the transgressor in a domestic violence situation is always the man. I could imagine a man reading the question thinking, well, the woman could be the transgressor and not the man, and spend some type of energy thinking about that, distracting them from taking the exam, and to what extent that kind of distraction could produce, a lesser score or something like that. I don't know if there's a way to assess that, but maybe we can tease that out in our survey.
And some of the way that we address that is just like gender neutral, names or referring to the actors as A, B, and C, and so that you don't get caught up in that, but really just the fact pattern itself. So.
Mm-hmm.
Yeah, that's just what I was going to add was we also, discussed how the portrayals of individuals. So if there's a fraud case and the potentially female is portrayed as being always susceptible and the victim and unable to accurately discern what was true or not, or is a witness in a criminal case and is always viewed as being lying or changing their minds or not having as good a memory, just what that may do subconsciously through stereotype threat or confirmation bias to the individual taking the exam and how they view their own ability to do well and process through it. So I think that the guiding principles addressed a lot of this, and I just want to express my gratitude to the State Bar staff and others in that working group, both on and off COAF, who really put a lot of care and detail into this, and also into thinking about the ongoing trainings for bar exam writers and graders on this, because I think they help to delve into some of the nuance that's needed.
Thank you so much for you guys' work on this. All right, anyone else have any questions, comments, concerns? All right, so next up on the agenda, we have lunch, but we're a little early. So do we want to move on to another item, maybe so we can have more time after lunch to have for ourselves in our day, or do we want to take an early lunch? I don't know. Did anyone have any suggestions?
I think
Keep going is my suggestion.
Yeah, go on.
All right, let's go to item 8C, update Blue Ribbon Commission on future of the bar exam. And so we have Donna Herskowitz here, and myself and Judge Christian are also on this Blue Ribbon Commission. Donna, we'll go ahead and have you go first to talk about the commission and what's going on with it.
Yes, absolutely. I'm going to, so there are a couple of things that I want to do to just sort of get you all up to speed on the work of the Blue Ribbon Commission. Just sort of talk a little bit first about the charter of the commission, follow that with a discussion of the guiding principles that the commission adopted, and then look at how we sort of the direction that we're heading in terms of what are the big questions that the commission is exploring, and how are they doing that in the different subcommittees that we've established at this point, and then what the plan is for the upcoming meeting next week. So to start, the Blue Ribbon Commission was charged with developing recommendations concerning whether, and if so, what, and I think whether is really sort of course, what changes to make to the California bar exam, and whether to adopt alternative or additional testing tools to ensure minimum competence to practice law. The charter includes, includes the evaluation of whether a bar exam is even the correct tool to determine minimum competence for the practice of law, and if not, what would alternatives tools be to establish minimum competence. If the commission says, no, we should retain a bar exam, then it's looking at, well, what kind of bar exam? The National Conference of Bar Examiners is in the process of updating the uniform bar exam, and they're calling it the next gen UBE, really looking at sort of redoing the bar exam. And so thinking about, well, is that what California should adopt? Right now, California has adopted just part of the sort of national test that is offered by the National Conference of Bar Examiners. Up to this point, we just used the MBE, or the multiple choice questions that are developed by the National Conference of Bar Examiners. And whereas other states, about 30 states, I think, have adopted other pieces of the national exam, essays and performance tests, California has used its own up until now. So thinking about sort of going forward, should we be looking at adopting the next gen exam and getting us out of the business of drafting our own bar exam questions, or should we stick with the California bar exam? And there are a variety of reasons, which we'll talk about some of them in just a minute, on things that could guide that decision. And then saying, okay, well, and if we go with the National Conference of Bar Exams exam, is that the end of the exploration? Because that's there's a debate on whether the national exam is testing the law of nowhere or testing the law of everywhere. But maybe we want, do we want California specific testing or California specific education if we were to select the national exam as the way to go. So and then the commission would be looking at okay, so then what should the exam include? If it's going to be a California specific exam or a California specific portion, what should the grading look like, right? Sort of all of that. So it's a pretty big charge. And so in order to ground us, I'm trying to pull up a document here. I'm searching. There it is. No, that wasn't it. In order to ground the commission, to think about, what, how should we think about this immense charge. What are the things that we need to make sure that we are keeping in mind as we are going through these questions of, should we go with the NCBE's exam? Should we select a California exam? Should we use something other than an exam to establish minimum competence? What are the things that we need to be keeping in mind? And here I'm going to share with you the charter that was developed, that was approved. Can everyone see that, or should I make it a little bit bigger?
We can see it.
Okay, so the guiding principles, not the charter, the guiding principles that the commission adopted are set forth here. I'm not going to read all of it, but sort of the key things that they have to keep sort of top of mind in answering all these questions and making these decisions is making sure that whatever is selected is something that allows us to determine that somebody possesses the knowledge, skills, and abilities required for entry-level lawyers for the practice of law, otherwise referred to as possesses the minimum competence needed for entry-level attorneys to be admitted to the practice of law. Ensuring that whatever the criteria is, whatever gets developed, whether it's an exam, a non-exam alternative, is designed in a way that would ensure protection of the public. That is one of the key functions. That the decisions on what we do are evidence-based. That we look at the evidence out there and help us guide our decision making. And then sort of some of the really key issues are fairness and equity of the exam or the exam alternative if we go with a non-exam route. We need to think about things like, how would they impact cost? How would what are the implications for the mode of delivery of an exam, or the types of exam questions that are asked, or the fact that if it's offered remotely or offered in the consistency of a test center. All of these things that impact access, that could impact disparate performance. That's all wrapped up into fairness and equity, and I'll show you how in just a bit. And then sort of that last one, which dovetails with fairness and equity, as I was talking about, minimize disparate performance impacts based on race, gender, ethnicity, or other such characteristics. And then the commission, also sort of concluded with sort of setting out that, hey, this doesn't outline all of the characteristics that we think are important in making the decision that we need to make, and it certainly isn't. It doesn't outline all of the characteristics which are important to set the foundation for the successful practice of law. But we are, and sort of just stating sort of the sort of other, some of the other issues behind what we're doing, which is being committed to high standards of integrity, civility, and professionalism in the legal profession. So making sure that all of the decision making and all of the thought processes are guided by these fairness and equity considerations, these considerations of ensuring that there isn't disparate performance, considerations that what we're doing is designed to ensure public protection and ensure minimum competence. So how are we going about doing that? Well, I'm going to stop sharing my screen for a second so I can pull up a different document, the November PowerPoint. I'm going to share again. Slideshow from correct slide. When the commission met in November, we looked at sort of the two key questions that we need to start with. Do we have an exam, or do we have a route other than an exam? Ultimately, there's also a question of, do we have both? But we identified what some of the guiding questions should be if we're for each of the subcommittees that are thinking about, do we go with an exam or a non-exam? And so for the non-exam pathway, applying those guiding principles, we said these are some of the things that we need to consider. How do the recommendations that we make protect the public? How do our recommendations ensure minimum competence in professional ethics and responsibility? How do our recommendations address reciprocity or portability for those California educated law students who want to go elsewhere, or for attorneys or non-California educated law students who want to practice in California? And are our recommendations mutually exclusive of the other pathway? Let me just make sure there wasn't another, whoops. I thought so. I was missing a slide. So so that's sort of so that was part of the exam pathway. And then the other key questions for the non-exam pathway also are, let's start with a question of in a non-exam world, right, where you have supervised practice or apprenticeships, things like that, sort of, how do you demonstrate minimum competence? What does that look like? How do you determine that somebody possesses the minimum competence for required for an entry-level attorney? Is there a question about the consistency of consistency across school types and law office study programs? Because in California, you can be admitted to the bar from an ABA approved law school, a California accredited law school, a California registered law school that is unaccredited, or participation. It's what we call reading the law, but participation in a law office study program. So is there an issue with ensuring consistency if we don't do an exam, if there are sort of curricular requirements that would happen in the law schools? And then looking at questions of how are fairness and equity implicated as measured by affordability, meaningful access to quality supervisors and other experiential learning, and how to scale such a program to California. The Blue Ribbon Commission was presented with some examples from the state of Oregon, from the state of New Hampshire, with supervised practice programs and curricular requirements in law schools. And all of the programs are significantly smaller and deal with a much smaller cohort of people than we typically are faced taking the California bar exam. And so, if you can admit 25 people into a program, but we've got 13,000 people over the course of the year who take advantage of this, we want to make sure that we're providing options that are equally available to folks, or make sure that we consider the availability and that we make intentional decisions about that. So those are some of the key questions for the non-exam pathway. For the subcommittee that's looking at what kind of exam would we do if we do an exam? Some similar questions. What should the exam look like in order to achieve the mission? What does the demonstration of minimum competence look like? So they would be looking at the knowledge, skills, and abilities that California had determined were necessary for entry-level attorneys. They would look at the knowledge, skills, and abilities that the National Conference of Bar Examiners had determined, and see where there's overlap. If the NCBE has made similar determinations about the knowledge, skills, and abilities, and they're developing their exam based on their determination of knowledge, skills, and abilities, if it's similar to what we think is required, that may lead the subcommittee in one direction. If it's vastly different, that may lead the committee in a totally different direction. And also sort of talking about, the tenets for building a better bar exam. We certainly, everyone has heard sort of, is the current bar exam the best way to determine minimum competence? And nobody is wedded to the way we do it now, and wanting to explore what are the tenets for doing this better and ensuring that we're building a bar exam that truly tests minimum competence. Getting also for the exam pathway, as we did for the non-exam pathway, looking at fairness and equity considerations. How are those considerations implicated as measured by cost, the exam delivery modality and format? And that might be, there are really different ways to test. you can test an exam content disparate performance. You can test with computer adaptive testing. You can do game-based test assessments. You can do exams that are offered remotely, in which everybody's setting could be more comfortable to them because it's their house, but could be wildly inconsistent. And some people have a better setup than others. What about the question type? Should they be, are there psychometrically sound conclusions about certain question types that some people tend to perform, some groups tend to perform better on than other groups? We need to know that if we're going to be designing an exam and deciding whether California should design its own exam. Also looking at open book versus closed book. Again, is there any literature out there that's looking at disparate performance? So by socioeconomic status, by race, gender, ethnicity, disability, if you have an open book option versus a closed book option. So these are all things that we'd be considering on the exam pathway. Also, again, some of the same questions that we looked at in the non-exam. How do the recommendations from this subcommittee on what an exam should look like protect the public? How do they address reciprocity or portability, right? Big difference if you go with the national-based exam versus a California-specific exam, potentially. Are the recommendations from the exam pathway subcommittee mutually exclusive of a non-exam alternative? And then ultimately sort of how that, how the answers to these questions play out for the decision-making that is going to happen. So the final thing I wanted to share with you is, and I'm going to stop so I can find this other document. Okay. Final thing that I wanted to share with you is, so what are we doing next week? So let me share this screen. So we're really getting into these questions, and we've had presentations from different states, from psychometricians, from scholars who have studied this, and we are continuing to learn from others in both the exam subcommittee and the non-exam subcommittee. And so we're seeking for the exam subcommittee next week at next week's meeting to potentially have enough information to make that preliminary recommendation about, do we go with the national exam or do we have a California specific exam? And so we are so we're having presentations to do that would do a deep dive into the recommendations that came out of the California attorney practice analysis, and looking at the extent of overlap with the practice analysis that's guiding the development by the National Conference of the next generation uniform bar exam. We've got a panel of psychometricians who will be presenting to us to talk about what the research is that's out there on whether you're talking other high stakes licensure exams, whether you're talking sort of other exams in general, in the legal practice, not in the legal practice, but what's the research on the impact of different question types and how to minimize a disparate impact. And we would be including data that we had gathered from our DIF study, as well as research on different testing modalities. They'll be talking about the research on the impact of remote exams in different settings versus those in more consistent test center settings. And also data from the post-exam survey that I had mentioned to you that we conducted after each of the remote exams. We're going to be parsing that data to see, were there commonalities, does the data show, and I don't have the answer to this, so these are the questions we're looking at. If we were to look at the people who responded to the survey, and we had pretty good response rates, are there certain groups that were reporting greater levels of disruption by taking the exam remotely? right? Because that might inform us. Are there, certain groups who were expressing that, doing a remote exam, at home on a computer like this they'd never taken another test that was remote, that was online, right? Sort of understanding if there are issues there about how a remote exam is delivered, that we might be able to learn just a little bit from the data that we have. And then also what is the research out there, if any, on open book versus closed book on different populations. And then we'll also have an update on the direction that the National Conference of Bar Examiners is going. We haven't had an update from them in several months, so we want to learn more about what they've been doing over the past several months. And then hopefully that'll lead us to a decision on what the recommendation will be. The non-exam subcommittee is meeting on the same day. And we want to learn from other professions and other jurisdictions how minimum competence can be determined through a non-exam pathway. And so we're going to have a presentation on the use of supervised practice programs in California in other professions, and a presentation on the use of supervised practice programs in the law in non-California jurisdictions, because we don't have that currently. And so we've got, that says provinces in California. It means provinces in Canada. So we've got people from Canada, from several provinces in Canada, who are going to be coming and talking about what they have is they call an articling program. So they'll be talking about that. In California, for other supervised practice programs, the medical profession is kind of a hybrid program, right? They've got exams, but they also have residency requirements and practical experience requirements. And so we want to hear from them about that and what their thoughts have been about just going with the practical requirements and not having an exam as part of that. And then also looking at what we can learn from California's provisional licensure program. We have some limited data because we do want to understand if we were to go with a non-exam pathway that requires you to have a supervisor and do a certain amount of hours or months or some period of time of supervised practice. What is the experience of our provisionally licensed lawyers tell us? Are there certain groups of people that found finding a supervisor more challenging? Right, that's an important piece of information to know and to figure out, does that tell us that we can or cannot proceed with a supervised practice program if it is going to be up to the individual to be able to find a supervisor in order to get the experiential requirement that's necessary. So that's what we're looking at in sort of holistically, and then sort of narrowing down sort of the first key questions that we really need some answers to. Ryan and Kristen are COAF's representatives on the group, and it's one of the reasons that we want to present to you so they can certainly know what concerns that you have that they need to bring back to the subcommittees and to the full committee. In order to do that effectively and to make sure that DEI issues, which is the reason we have COAF representatives on the commission, are addressed on both of those pathway discussions. Ryan and Kristen have split up graciously. So Ryan is on the exam subcommittee and Kristen is on the non-exam pathway subcommittee. So we can make sure that we're asking the right questions in both of those pathways as decisions are being made or recommendations are being made. Because ultimately the subcommittees will recommend to the full Blue Ribbon Commission. The Blue Ribbon Commission will recommend to the Board of Trustees at the State Bar and to the Supreme Court to ultimately adopt the direction here. But obviously we will take incredibly seriously the hard work and recommendations of this group. And so we want to make sure that we're being as thoughtful as possible as we are developing those recommendations. So I will turn it over to Ryan and Kristen to add anything more on that. And I saw, Heather, you had a hand up earlier as well.
Yes, Heather, do you have a question you want to ask?
Donna answered it in her presentation.
Okay. All right. So I just wanted to add that, yes, we're still seeing presentations from experts, psychometricians, and people from other jurisdictions who have reformed their bar exam. I'm excited that at our next meeting, we get to really dive in and address whether we're going to adopt the next gen uniform bar exam or move to a California specific solution. I will add, just for the edification of this council, that when we received our initial presentation on the next gen UVE, there was nothing specific to go off of. They just pretty much said, you know, this is what we hope to do for the next gen UPE, which makes me believe that if they can't give us anything specific to address and weigh and scrutinize, well, you know, I mean, there's nothing really to adopt at this time, but we'll get that we'll get to that when the time comes at our next meeting. Kristen, Judge Kristen.
Thanks, Ryan. I mean, to Donna's point, and I'm on the non-exam pathway committee. You know, to the extent that anyone in COAF has questions or concerns or thoughts on that, please share them with me. You know, we've split up in groups, and so I haven't, you know, Ryan and I don't get to talk as much about, you know, and see, because we don't see the same things now. But I want to say that every time that this commission meets, I am struck with the gravity of what we're doing. I think there's 25 of us or so on this commission, and we're making a decision that impacts, you know, tens of thousands of people after us. And so I am, you know, no expert on this, and want to lean on all of you if you have, you know, things that you've thought of, for me specifically about the non-exam pathway. If you have ideas or thoughts, please share them, and I will make sure that I bring that back. And as Donna said, you know, my big issue, and one of the things I raise at every subgroup meeting is this idea of equal access. If we're going to do a supervisory model, who's getting the best supervisors from the biggest firms? How much is everyone getting paid the same amount? Are non-ABA schools also, you know, getting the same access? And so, you know, these are the issues that I continue to raise. And you know, if we were to undertake this a non-exam pathway, we would certainly be the biggest state to do it. So there's lots to think about when it comes to the DEI issues that we all care so very deeply about. So please reach out to me if you have anything.
Thanks, Judge Kristen. We have Shalak and Heather and Sal.
Thank you. Judge Rosie, you mentioned a couple of the things that were on my mind. One thought was whether or not, and I apologize if I missed it in your excellent presentation, Donna, but whether or not conversations with the ABA and particularly ABA accreditation have been included in this. Some of you may know that part of ABA accreditation is a certain amount, number of bar passage within 2 years of graduation for first-time takers, and so and retakers. And I'm just curious as to the ABA's weighing in on if this sort of non-bar path were to be taken and how that would be folded in accreditation, particularly because I can see at least the ABA accredited schools, if not having any pushback, certainly having concerns about how some of this may roll out and how they can be in great compliance. And my mind with that was also going to then, as you were saying, Judge Rossi, making sure that those supervisory opportunities are really thought through when we think about career opportunities, career services offices within both the ABA and non-ABA accredited schools. I'm wondering if there's anyone on the commission or maybe a subcommittee could reach out to the various deans of career services at the ABA and non-ABA accredited schools. I have many of those contacts, so I'm happy to put you in touch with them. There is a an organization of LA area career services and law firm recruiting managers, which may be interested in, if this goes down this road, obviously not at this moment, considering how this could be implemented in a way that is fair and just and equitable. So I just wanted to put that out there as thoughts for the future implementation if it went that far. And also considering, again, for those who may do what we call the baby bar, how that may impact for non-ABA accredited schools, or even we have a requirement for some who may be academically dismissed. A way they can get around that is if they do the baby bar and show, a certain level of proficiency, what some of those considerations may be as well.
Yeah, and Shalak, you bring up a lot of great points, and one of the things is, what I identified sort of are the preliminary questions. There are a lot of other questions, and so, for example, if we go down the exam route and a California specific exam route, there've been discussions at a national level about, is testing, doing the entire bar exam, immediately post your third year of law school, is that the right time? Should you space it out so you basically have something after your first year and something after your second year, right? What should you do differently? So those kinds of timing questions would come up in those future questions. And as to the ABA issue, certainly I think in our minds we were thinking, it's the equivalent of bar pass or admission to the practice of law, but we would certainly need to work with the ABA to make sure that they would interpret it the same way. If we go down to a non-exam pathway, would admission to the practice of law, so long as it happens within those 2 years, the equivalent of bar pass for their statistical purposes, for their determination of whether or not somebody maintains their accreditation.
I apologize. I also wanted to mention, this is slightly ad hoc, that I am in fact Canadian and from Ontario, and so I'm familiar with the articling system with the Upper Canada Board, and have many, many thoughts about ways that it is superior to, but also needs work with the various US licensing systems. So happy to always chat offline, especially after you have that presentation about that. Yes.
Thanks, Shalak. Heather?
I have lots of thoughts too, probably coming more from me being like a member of the public than a member of COAF. So take it with that grain of salt. But I will say, like, throughout the presentation, I have this mug that sits on my desk at work that says, "Don't confuse your Google search with my law degree." And this was kind of coming front of mind to me because I feel like people just think it's so easy to be a lawyer. And my question when my hand was risen earlier, Donna, was because you hadn't scrolled down yet to show that you were going to analyze like the medical profession and other professions where I feel like people wouldn't question that you need some sort of minimal competence, but I think people think if you have an opinion and can read, then you can be a lawyer. And so I just want to make sure in looking and evaluating how we grant more access that we don't compromise that for minimal competency. That being said, I also think I have two thoughts to Ryan on the exam subcommittee. I just personally would lean into and support a national bar exam, because I think as younger generations are getting more opportunity to work from anywhere or move around a lot, the ability to be able to practice from state to state, I think is crucial, and not have to sit again for another exam and another exam. I have a lot of young mentees who are like, I'm going to take all these exams back to back. I'm going to take the California one and then a month later take it. And that sounds super stressful. And I'm sitting listening to them as law students thinking, you really have no idea how challenging that might be. But if you had some uniformity across the exam nationwide, even if the passage rate differed, I think, from state to state, but at least the exam was the same, I think it would allow for more flexibility as our society is just moving in that way. On the non-exam subcommittee, I think something, Kristen, to take into consideration is, how does this affect imposter syndrome? Because I think already a lot of diverse lawyers, new diverse lawyers coming into the practice early on, feel like even when they've passed the bar exam the first time and they've gone to ABA accredited schools, they walk into situations where people are scrutinizing if they should be there. And if you differentiate how you got there, I think that only compounds, that level of self-doubt or analysis or external scrutiny. So I think if your committees aren't taking that part into consideration too, that's another part of the analysis and feedback from other professions or other states that would be helpful.
Thank you, Heather.
Yeah, and one challenge certainly, Heather, for that, if state of California were ultimately to adopt the NCBE's next gen uniform bar exam, that alone does not guarantee that you'll be able to move that passage of that California exam to other states. Most other states are not admitting to the practice of law in their state somebody who graduated from other than an ABA accredited law school. And so because, and in most states, that's what they have. They have ABA accredited law schools. California has 50 law schools, 20 or so of which are ABA accredited. The others are not. And so one of the conversations, and we'll be doing a survey, one of the things that we'll be doing is a survey to other states and ask, if we were to adopt the uniform bar exam, can we revisit that question of whether everybody who got above a certain score, the score that you said in your state, whether everybody could possibly be admitted? If the answer, and then what if we did a California-based bar exam? Would there be the possibility for anybody to be admitted, or no, because it's a different exam? So there are tricky pieces to that question because of the different types of law schools that we have in California and the reluctance of many other states to allow those from other than ABA accredited schools to be admitted.
And I just wanted to say, to reiterate what Judge Kristen said, just listening to it, it's so heavy and so hefty. And I'm so grateful and appreciative to the three of you for taking this on and being part of this conversation. It is a very important one, and I'm very grateful.
Thanks, Heather. Sal? And I see Sarah, your hand was raised briefly. Okay, Sal.
Thanks, Ryan. And thanks, Donna. That was a great presentation. I don't know why I was still waiting for you to go back to the 235 days of trial for those things you taught. Anyway, and Heather, I'm going to have to borrow that one, because that Google's, don't confuse your Google search with my law degree, because in my practice, I deal with a lot of opposing counsel who I taught myself law school. But one of the things, I guess, for both Judge Kristen and for Ryan, and thank you both too for this really monumental work, and it was in Donna's presentation. There was the paramount questions you're answering of how are we protecting the public for both of those. But I think maybe if you take a step back, is asking ourselves, what is the more paramount concern for us at the state bar? Is it to protect the public or produce more lawyers? Because in protecting the public, if the argument is, well, we need to have an exam for minimal competence because we're protecting the public, I doubt, and this kind of leans over to Ryan's side of the house, I doubt that doing identifying issues and writing an essay within an hour, that's not really reality. I don't know. I'm sure in your firm, you give people longer than an hour and a half to read and write a memo on an issue. So is that really testing enough to say, well, now we know they can write, so they're going to protect the public from here on in? I doubt it. On the Judge Kristen side, one thought maybe is, in Latin America, there's a lot of schools where people decide they want to be lawyers and they go to college for longer than 4 years. They go to college for maybe 5 or up to 6 years. And when they come out, they have the designation of a Juris Doctor or something equivalent to that. I don't know the right title yet. they still have to take an exam, but they've spent longer in school. And I know this is really monumental now because you're talking about changing the whole collegiate system in America. But if we did something where the law schools maybe started earlier, like that, when you're in undergrad and you're thinking about law school, they have the JD MBA type of programs now available, but start talking to the students now about adding 2 more years to your college to get the law degree in there. And during those 2 years, they could dedicate it to the apprenticeships, the internships, the externships, where they are working day to day with folks like Ryan, folks like me in private and public sector, where they're working, and we can make better assessments of their abilities, their technical knowledge, their hard skills, and more importantly, their soft skills, which really will protect the public in the long run. Something like that, I think, would be great as well. So maybe something to think about in the non-exam world. Can we do something to reshape the way the educational system is helping us train lawyers, where we can develop a way to keep them in school for maybe another year or 2 longer, but give them that sort of provisional supervision by lawyers and law firms to help them become better lawyers in the long run.
And you made some really good points, Sal. And again, sort of some of this goes to sort of the next step questions after we answer the first set of questions. Because I think I think California's practice analysis, as well as the National Conference of Bar Examiners practice analysis, really sort of lead to the pretty natural conclusion that that rote memorization is no longer the way to test whether or not you're protecting the public, right? And that it's a focus on the skills, right? Right. You need to be able to analyze. You need to be able to issue spot. You need, but recalling the precise 3-prong test may not be useful. Knowing that there's a test is important, but we know that many people do then look up exactly what that test is to make sure that they are applying everything correctly. And so I think sort of no matter which way we were to go, the exam of the future looks very different than the exam of today.
Yeah, that's why I like the open book test, because that's really closer to reality. I mean, if you're going to assign someone, they're going to go look it up anyway, and they're going to, maybe we give them a little longer time to take it. Maybe it's a day exam, because if you can't assess someone's skills in a day, is the extra day going to help? I don't know. But maybe if we give a day where we're dedicating them to on an open book test, see how long it took them to look something up and then make the analysis and actually write it up. That's really indicative of their proficiency in an office or working with a client somewhere. That's why I'm a little lean towards that open book idea.
Thank you, Sal.
Thanks, Ron.
Heather?
And Sal just reminded me with the statement about the Latin American countries. So before COVID, the National Bar Association used to do an annual or every other year international trip to do a comparison with the practice of law in other countries. And I only had the privilege of attending once, but I went in 2016 to Cuba, where we took 100 lawyers from the United States, and we went there for 5 days and did MCLEs with the Cuban lawyers and learned about how they licensed and practiced. And that's when you just refreshed my recollection about that, Sal, that they talked about how the students went to school and went through law school. I can't remember how many years that all was. And then they did have a year, at least a year of apprenticeship before they actually took the exam. And how helpful that was from a practical standpoint of really evaluating. So it made me think about Cuba being a good example to analyze, but also I know people, rave all the time, Shalak, to your point about the barristers in the UK and what that system looks like. And so taking into consideration some of those alternative processes, I think, aside from Canada, would be really interesting. So
yeah, and I liked your idea about more of a national view of the bar exam, because I think you said it, Heather. I mean, in these days, I mean, everything's becoming global. And now with the digitization of almost everything and the interconnection of things all over the world, everything is global. So, having a bar exam that really, if it's a minimum competency exam, why what makes California so different that it cannot attach itself to a national bar exam system. I mean, there are unique laws like any other state, but nothing so unique to say like, well, you have to be a California lawyer to do this for a California company because it's in California. That's really not true anymore, because most California companies, if they haven't moved out of state, are doing business globally anyway. So a legal professional really has to have a global perspective about the work they do for their customers and for the people they might represent who are engaging with those customers, as well as a global perspective of the reach of that particular enterprise or the particular individuals, consumers who are tapping into the world.
And the things that we test for specifically in California, like community property, don't come up in, a global companies or a California-based company's day-to-day work anyway. Very helpful in our personal lives, but not necessarily from a corporate standpoint. Versus in other states like Texas, where they're actually testing on oil and gas and mineral rights because their businesses are really tied to that, and so they have very specific courses around that.
I think Sal just made our task even more daunting, Kristen. I think he just added, in addition to what does it take to be admitted to the practice of law in California, he suggests he's adding restructuring the practice of law in general to make for global lawyers. So we'll put that on our to-do list.
You said we're trending forward, Donna. We're trending forward.
Who will be the licensing authority for a global law license?
Yeah.
Ryan
and I weren't vetted for that.
I'm not trying to make it more difficult, but I think really, I've heard too much about the state bar saying, well, we're really trying to protect the California public and we're really trying to do this, and all the sort of adages that we were hearing before. That, in this day and age, with everybody being remote or having the ability to be remote, and with us being connected to absolutely everything at the tip of our, with the fingertips we have on our devices, those kind of old arguments for why the state bar, California bar, has to be only California and the only one, et cetera, they've kind of diluted themselves over the years. So that's why I'm just suggesting that if we have a global perspective, you don't have to change the curriculum, but you do have to change the way you're testing for people who are taking it.
All right, any more questions or comments? Seeing and hearing none, I guess we'll move along to a much needed lunch, because it certainly worked up an appetite with this discussion. What time should we return, Elizabeth?
1 o'clock, is that enough time for everybody?
Sounds good.
Okay, thank you.
All right, we'll remain in recess until 1. The recording has been reinitiated, and so let's get going. I think we are about 30 minutes ahead of schedule, which is, or maybe 15, which is nice. And so we're gonna take 2 items together. We're still in section 8, and we're taking items D and E together. All right, so I'm gonna turn it over to Elizabeth.
Thanks, Ryan. So the items D and E are the diversity report card and the 2020 impact survey. I know we previewed both of these items to the council at our last meeting, but we've had lots of development since then. The decision has actually been made for us to actually analyze both sets of data together. We think that some of the satisfaction questions in the diversity report card will really complement some of the findings that are coming out of the impact survey. So in order to do that, we need some time. And so we've made the decision to delay publishing the impact report, which we had been planning to do before year end. So we're going to delay it about a quarter. And publish the diversity report card along with the impact report in about March of 2022. So we're really excited about this opportunity to, really look and dive deep into both of these data sets and kind of cross-reference them together. So we just wanted to provide that update. Wanted to thank our working group on the impact report, who saw a lot of data and gave us a lot of really great feedback. We held some focus groups on the impact report findings, and you know, a lot of various stakeholders in various sectors also provide us a lot of data. So we're really excited to have you know, to be able to produce kind of a larger work product that we hope will be more impactful for the legal profession. So as we get closer to kind of putting those two data sets together and you know, maybe seeing some trends, we will be reaching out. There were two working groups, so I think we'll reach out to the two working groups on the report card and in the impact report to share out the initial findings and get some reactions and feedback on that. So I anticipate that will probably be late January, February or so.
All right, thank you, Elizabeth. Any questions on that? Okay, let's move along to item F. Elizabeth?
Yes. So item F, this is an update on the implicit bias training module. So I'm really pleased to let everybody know that we actually received the final version of the training module this morning at 7 a.m. So I haven't had a chance to take a look at it. But we are excited to just take one last pass at it. We'll then have to take some time to upload it onto the State Bar's e-learning platform, but then we will have 1 hour of implicit bias training available for free for all attorneys. So I really wanted to thank Novella for providing feedback, as well as former COAF members, Judge Esther, as well as Connie Broussard, for providing input both on this particular MCLE as well as a prior elimination of bias rules revision. Also wanted to give a quick recognition to Heather, who for her recommendation for our subject matter expert for our MCLE. We've been working with Catrice Monson from Right Size Media, who's really just been phenomenal. And so we hope that this MCLE will be useful and that lots of attorneys will be able to take advantage of it. We made the decision early on in development of the MCLE that it would kind of be a more basic implicit bias training, and then perhaps in 3 years, you know, with the MCLE cycle, we COAF or might be able to revisit it again and maybe have like a, you know, implicit bias 201 type training, so that it's like at the next level up. So that's something that you know, we can think about when we talk about work plan, as well as potentially other trainings that we can maybe implement.
Thanks, Elizabeth. I had one question that is somewhat related to this topic, and this comes originally from Pat Lee, our liaison with California Law Pathways. She asked me if there was any status on the proposal from the to adopt a 20-hour voluntary DEI program. This is something similar to the policy adopted by the ABA House of Delegates.
So I think we are very interested in working on that. A part of an idea that we had for like a State Bar leadership seal for legal employers, to kind of put into action, you know, some of the calls to action we have in the diversity report card is a project that we would like to work on and kind of fold that requirement into that. So that is on the radar, and I think we can make it a part of the work plan.
Thanks. And can you just explain with a little bit of clarity on exactly what this proposal is for the DEI policy?
So the ABA passed in August, their Conference of Delegates passed the resolution to recommend 20 hours of DEI activity for attorneys as a benchmark or a goal for all attorneys. And my understanding that it is a pretty encompassing rule. So, you know, 20 hours, it could be mentoring or participating, you know, on COAF, for example, similar to their, you know, pro bono hours goals of 50 hours. It's to encourage attorneys to participate in diversity, equity, inclusion work and advance it in the profession.
Okay, thanks. Okay, so any questions about that from anyone on the council? All right, let's go ahead and move on to the next item, item G.
Okay, So item G is addressing retention in the legal profession through law school loan repayment. So I really want to thank Judge Kristen and Heather for their participation in our informal working group that was made up of members of the Legal Services Trust Fund Commission as well as the Access Commission. We're currently working on a proposal for next steps related to a statewide LRAP program. And so we'll be sharing that out as that becomes more developed with Heather and Kristen, likely in January. And then we'll have another working group meeting with members from the Trust Fund Commission and Access Commission following to move this forward. And then, of course, we'll have an update at our February meeting.
All right, thank you. Any questions or comments about that? All right, let's go ahead and move on to item H.
Okay, so early pipeline to the profession outreach materials development. So we're still planning to develop an outreach video with Disney, and I understand that our plan is to either move forward either later this month or in the new year. So stay tuned for more information on that.
Thanks. Any questions on item H? All right, let's move on to item I. And it says I'm supposed to present on this. This is an update on the Judicial Council request for assistance on judicial diversity initiatives. And so I don't have anything to update on. Do you have anything, Elizabeth?
No, I don't.
Okay.
And, yeah, and typically it would just be if we had any requests from the Judicial Council for any participation.
Okay. And based on this item, it seems that because I'm now the chair, am I supposed to be attending the Judicial Council meetings, or is that what's expected of me?
I don't think so. And you know, it may have been just my error because Judge Esther, I think, was involved in that prior. So I think any updates from Judicial Council would come from Judge Dulcich.
Okay.
Yeah.
Excellent. All right. Thank you. All right. Any questions or comments on item I? Okay. All right. Let's go ahead and move on to item J, which is a discussion about additional diversity and inclusion initiatives. And so I'm presenting on this one. And so I have a story for you guys because there's a new thing that came up and it's outside the work plan. And we're going to talk about adding it into the work plan in the next item on the agenda. And so what occurred basically about 4 months ago was I have a mentee who attends UC Davis School of Law, and she was going through a bout of imposter syndrome. And she knew more about it than most people, but she wanted to learn more from peer-reviewed academic resources so she can kind of figure out what was going on with her. What was occurring was she was in her summer associate program at a top firm, and she just felt like she didn't belong there, and it was impacting her work. Things that she could normally do very easily, like send an email, were just almost impossible for her. Like she was second guessing herself to the point where she was pretty much unable to perform basic tasks. And she eventually did not get a job offer. She didn't perform well, and she feels like she kind of psyched herself out. And you know, she's an excellent student and she's going to make an excellent attorney, but she had that issue and she wanted to find more about it. And I tried to help locate some resources for her. You know, I recommended she talk to someone at her law school or see a therapist and all of that. But one thing I realized is that when you go on Google and you try to find like credible peer-reviewed sources, like you can't find anything, right? And that kind of was a problem for me that I uncovered. And it made me realize like issues of imposter syndrome can really affect not only performance, but can create a public protection issue. If you're an attorney and you're going through it and you're not able to provide competent legal advice, it's a public protection issue. And it's also an issue that falls under the jurisdiction of COAF, right? Diversifying the legal profession. Oh, what about the number of people who kind of deselect themselves from the legal profession because they think it's not for them, because they're experiencing something like imposter syndrome in undergrad or maybe even high school. You know, if people learn more about it, how it affects them and how to defeat it, maybe that could increase the number of diversity diverse attorneys in California. And so I decided to kind of examine how we can essentially create a imposter syndrome resource page on the State Bar website that contains a few peer-reviewed articles that explain what this is in the context of law practice, right? Also to provide kind of short videos, a few of them that gave people confidence, like, you know, diverse attorney, so maybe someone like myself saying, you know, I went through it, you can get past it, I believe in you, stuff like that, words of encouragement, right? And then also maybe a video of an expert talking about imposter syndrome. And this is something that I had actually been working toward accomplishing on my own. I've already held about 4 meetings with a sociology professor, Bruce Haynes at UC Davis, and the DEI fellow at King Hall, Alexis Elston, who I attended law school with at Hastings. And we have essentially created like a rough sketch of what this page can look like with the help of Carolyn Ross Burnett at California Law Pathways. She's on the board. She's actually studying imposter syndrome as a PhD student. So she sent me a number of articles that both Alexis, Professor Haynes, and I are going to be reading within the next couple of months to see which ones are good to provide on a resource page. Also, there's a professor at King Hall who every year she does a lecture on imposter syndrome, and it's recorded. And so this upcoming year, when she performs that lecture, it's going to be recorded with, I guess, a little bit more resources put into it, with the hopes that this could be something that goes on this resource page, right, for the State Bar. And so I spoke with Leah, and Leah said that the best way to go about this would be to add this new item on the work plan. She said she supports it. I spoke to a couple of the members of the board of trustees, and they also support it. And so we just need to put this on the work plan and see how we can formally go about bringing this resource page into fruition, which I think will be really helpful for both practicing attorneys and attorney hopefuls. And with that, I'll go ahead and open up discussion. Go ahead, Stephanie.
Thanks, Ryan. I just wanted to know, I know it's very, very early in the stages, but where exactly on the State Bar website was kind of the idea for having this show up?
So yeah, this is something that's kind of manifesting itself organically, but the thought was that there is a part of the State Bar website that is dedicated toward students who are taking the bar exam, and there's resources for those bar candidates to learn how to kind of defeat imposter syndrome within the context of taking the bar examination. And so it can be kind of somewhat tethered to that or around that.
Okay, got it.
So Ryan, this is Pat. It's going to be a part of my liaison report, but the first day of the 2022 Pathway Summit is going to focus on overcoming invisible barriers for student success. And the two areas that they're going to focus on is imposter syndrome and lack of belonging. And Rod Fong is developing those, and he's been pretty much active in that area. And he's identified a couple of experts that will be speaking to that. That whole first section of that day will be devoted to identifying and defining these concepts, and then identifying them in the classrooms, and then how to overcome them. So there's probably going to be a lot of information that he could share with you, specifically in terms of the experts that he's using and the resource materials and so forth. And based on what you're thinking of posting information on the State Bar website, I'm also assuming that that's part of his goal as well, is to have those materials be part of the Cal Law website, so that the pathway students and teachers and faculty can access that as well.
Absolutely, that's great. And if that presentation can be recorded, maybe we can talk about, down the road, using that in some type of way. I also very much intend to, be present during that presentation.
Okay, great.
Thanks. Heather?
I love this idea, Ryan. Thank you so much for raising it for all of us. And I know we had talked maybe a year ago too about having a resource page on the State Bar website for a few different things that we wanted to make sure people had access to, information about like the minority bar associations and about scholarships. And so as we think, I don't know if that ever got stood up, was my first question, but the second part is, if we put together this curriculum or these resources, I'd love to see it not only placed where you just suggested in the resource page for students who are about to take the bar exam, but this occurs throughout people's practices, right? I mean, I have conversations with people and that talk about this at almost every stage of their practice. So I think having it in dual places on the site would be helpful too.
Thank you, Heather. And Michael?
Yeah, I agree. This is a very interesting idea, and I think it could benefit a lot of people. But I want to echo one thing that Heather said, which is just making it available or as widely available as possible, because I'm not sure that folks who are facing these issues, I'm not sure that their first impulse is to go to the State Bar website. So the PR campaign will be important. I know that the California Lawyers Association started I'm going to get the name of the program wrong, but something along the lines of the diverse voices of the legal profession. And it's a video series where they have folks do a short interview, just self-directed short interview that talks about overcoming barriers. And it sounds like there could be some overlap and potential for collaboration there.
Absolutely. That's certainly an avenue that I'm willing to explore. And I hope that when we formalize this item as an addition to our work plan, we can create a small working group so we can explore all those avenues. Thanks. Elizabeth?
I just wanted to respond to Heather's question of whether a resource page for Minority Bar Association scholarships. So CLA actually compiles those resources. And so we link to it from the COAF page to the CLA page. And I also just wanted to echo Michael's comments that I know that CLA, while they aren't focusing specifically on imposter syndrome, they do a lot of work around DEI, and they have a health and wellness committee that's looking at some issues related to work-life balance and that sort of thing that may intersect with some of the work that we do. So we should definitely be open to collaborating and partnering with them.
All right, thanks, Elizabeth. All right, does anyone have any other questions about, I guess, my vision for this new project? I expect this project not to take a lot of time or resources. One thing that was kind of expressed to me was after I'm long off of the Council on Access and Fairness, the State Bar will have to update it if new information comes out. What I would like to do is kind of create a partnership with the State Bar and UC Davis so that if and when that information needs to be updated, you have a huge college of experts that are available to help work on that, as opposed to recommitting the resources that the State Bar has.
Do you need any help with this at all, Ryan? Like, you looking for people to help you out with this?
Yes.
Sign me up for that. Happy to help.
What about you, Heather and Michael? Okay.
Yes. Sorry, couldn't get off mute fast enough.
Okay, so one thing though, I think we have to keep the members of this working group small, smaller than what constitutes a quorum, I think.
So that would be 5 members.
Yes. All right, so 1, 2, 3, 4. Okay, one more. I saw Shalak and Stephanie.
I'll let Stephanie take this one, but please know that I am very, very, very interested in this and work with a lot of law students, not just at my law school, on this very issue. So
Shalak, you can have it. I'm happy. I was actually also mostly interested as somebody who went through something similar to what your mentee went through, Ryan. I could be in the video, so I don't need to be in the working group. So Shalak, go ahead. You can take that one.
Okay, and I'll make sure to note that you are a candidate for the video, which is great. All right, thanks. All right, so that's it. Let's move on to the next item. The next item is a review of COAF work plan approved, which will be, I guess it was approved in March in 2021, and it will be reapproved in March of 2022.
Yeah, so the Board of Trustees annually approves the COAF charge and work plan. And typically it goes to the board in March for the year. So what I'm about to show up on my screen is what was approved in March of 2021. And so we'll walk through it kind of quickly. And I'm actually going to suggest that we maybe talk about like what we've accomplished and what we're going to like check off of our work plan, and also talk about what we might want to add at the same time, based on the rich discussions that we've had already today.
All right, thanks.
And the other thing I wanted to point out before I share my screen is that the Board of Trustees is coming up, or the State Bar is coming up on the end of a 5-year strategic plan. The plan was 2017 to 2022. So in January 2022, the Board of Trustees will be doing some strategic planning and may update our diversity, equity, and inclusion goals and objectives. And so I think we will make a lot of headway today in talking about what we would like to do as COAF for the next year. And then the board will meet in January, and then COAF will meet again in February. And I think at that point, we can look at what the board's approved for their goals and objectives related to DEI, and integrate and update as we need in February.
All right.
Okay. Oops. Sorry, I just have too many documents open right now. Okay. So hopefully everyone is familiar with the charge of COAF. We did do some revisions to it in 2020 to really reflect kind of what we're doing. It is broad purposely to give a little bit of flexibility to the work that COAF does. I encourage members, if you haven't had a chance to take a close look at it, to do so. And then if there are comments about it, you can email me directly. And then in February, we can talk through any revisions you might want to make, if there are any. Okay. So as you can see in the work plan, these are the activities. And then every activity is tied to a State Bar strategic plan goal and objective. And so that's why, I think we'll get a lot of the work done on developing the work plan for 2022. We do need to wait to see what the board, changes or updates in the strat plan related to DEI. My understanding is for 2017 to 2022, the board had some very specific goals and objectives. For example, identifying means of supporting existing law school programs to improve retention. My understanding is that the board will likely take a step back and have a little bit broader objective, and not like necessarily specific projects. So that's my understanding, but of course they're not meeting till January. For law school retention, we've actually made a lot of headway. We're really close to finalizing the law school retention report and resources, as Crystal reported earlier today. We've completed this reviewing and analyzing the law school survey findings. We're in process of doing this. And so this likely, I think we would want to change this to the first quarter of 2022. So March.
Go ahead. Yeah.
Okay. And then I think we'll, as appropriate, COAF will continue to participate in the law school assembly. And then as was reported at our last meeting, the California accredited and registered law schools, they're being asked to report more specific demographic data for the students as well as enrollment and attrition data, and that's a phased approach. And so we'll continue to review that data as it comes through. The review of this data specifically is to be able to look at that data set with the law school survey. And so that's why the date is March 2021. But I think for the fall 2020 data, we'll complete it along with the report by the first quarter of 2021. And then again, we will continue to track California ABA school data with their 509 reports and to try to identify any trends. So I think, some of this work will be ending, I think we may want to, based on what our report and findings are with the law school retention study, COAF may want to do something in addition to that. Because we're not at that point yet where we can report out, what exactly that might be. My suggestion is hopefully by our February meeting, we'll have a little bit more information on what the final report will look like, and perhaps add something to this specific item at that point.
Okay, thanks.
Okay. And this next item is related to the bar exam question development, so the DIF working group, as well as question development grading analysis. So that we've done a lot of incredible work on this in the last 5 years. So thank you to everybody who's worked on all of that. We haven't exactly codified D&I principles in bar exam development, but there are now definitely more, there's like an outreach plan, and there are trainings, implicit bias trainings that happen regularly for graders and question developers. So I guess I leave it to you if you want to just continue to monitor this. I mean, we have an item here, recommend State Bar require and provide implicit bias training during annual onboarding and orientation for proctors, graders, and edge team. So that's ongoing to monitor progress. So I don't know if we wanted to take a look at this, or if you thought like, more needed to be done on that.
I don't know, does anyone have any suggestions? Maybe we can kick this to the DIF working group to see if they can discuss this in their next meeting.
Okay, I see Shalak. I can't see everybody, but I see Shalak nodding.
That would help a lot, Brian. Thanks.
Okay. Okay, great. And then this is the DIF working group work. And so as Heather, Shalak, and Sal reported earlier, they will have some guiding principles that there are guiding principles they're working on, and it should be going to the board, I think early next year. So I think this work would be done by the first quarter of 2022.
So we don't need to have those in time for the state bar meeting in January then? Or is that not one of the topics you're going to be discussing?
The guiding principles?
Yeah, I mean, with respect to, you started out, Jesus Christ, sorry, my cat's like decided to come up on my desk today. You started the conversation with the fact that the state bar's meeting in January, I think you said, of 2022.
Yes.
So do you need any of this, what we're on right now, done before that meeting? In other words, another way to ask that is, at the state bar on January, are they going to decide or discuss or debate any one of these topics specifically?
No. This work plan does not go to the board until March.
Okay, great. Okay, perfect.
So that's a good point, Sal. So actually, the DIF working group is meeting again in January. So let me just make a comment that we'll update this based on kind of what the update from the January DIF working group.
Yeah, that'll help, because then we can, when we get together, we can have that in mind of come up with some sort of deliverable that might help us edify the state board in March or whatever.
Okay. Okay, and this is ongoing. Work with the Office of Admissions and develop and implement key performance factors that will ensure State Bar is broadening education outreach to legal community, including consideration of broadening geographic restrictions and outreach to affinity bar associations to widen recruitment of graders and pretesters. So this is ongoing work, and I think it's been a great partnership with the Office of Admissions. Whenever they put out their call for graders and pretesters, I usually forward that to COAF to spread out to your networks as well. So I mean, I think that's something we can keep.
Excellent.
Okay. So this is the Bar Exam Strategies and Stories program. So if you recall, in May, I believe, yeah, I think May, we had a presentation from the researchers for the study. It's an intervention that focuses on stereotype threat and imposter syndrome. And so this intervention is being offered again for the February bar exam. I'm not exactly sure how long the study will be, but at a certain point, because the findings have been so positive to improve bar passage rates, especially for bar takers of color and first-time bar takers, I know that the State Bar is very interested in continuing this intervention beyond the study. You know, I think what might be an appropriate is just for us to have another update when this about what the about the study, and then you know, that there was a desire when we created this work plan last year to develop a communication strategy to outreach to law students and bar applicants to participate. So that definitely is something that we can keep on the work plan if that's what the council wants.
Yeah, it was my belief or assumption, I guess, that this was being widely communicated to every person who signed up to take the bar exam.
It is.
I mean, and I know I'm kind of shooting from the hip here, but I mean, what more can we do than that? I mean, if they sign up for the test and they're told to take this, I mean, should we be doing more, like communicating, I guess, the value of this more above and beyond what's already communicated currently? Does anyone have any suggestions?
Novella?
Yeah, I'm happy about the results. I imagine more people would participate if they understood that there actually was a correlation in improving bar passage rates. So I think similar to like the outreach efforts that we've done for other like pieces of information, like diversity in the legal profession, having videos on that or creating flyers, it seems like whatever we can do along that lane to publicize this information would help. And then also I imagine that law schools could provide that information, as well as legal employers who hire people who are earlier in their career.
So the State Bar has tried to do a lot of outreach about the program. I know that similar to how the researchers came to COAF to make a presentation, they made a presentation to the Board of Trustees. They made a presentation to various law school meetings that the State Bar convenes. There is a pretty wide social media campaign for those who register to take the bar exam to sign up for it, and everybody, as Ryan said, receives emails on it. I think one thing that might be we might be able to do is with the imposter syndrome resources on the State Bar website, kind of connect maybe the two. Because this intervention does address stereotype threat and imposter syndrome.
I like that idea. So I'm kind of, I got 1 foot in and 1 foot out about whether or not we should take that bullet point off the working plan or leave it on. But out of an abundance of caution, let's just leave it on.
Okay.
Yeah.
Should I just put a comment here just so we should review it again in February?
Sure.
Okay. And then I added continue and you know, after the meeting, I can work with Ryan and Kristen as chair and vice chair to refine kind of the language. But my note here is just to continue and monitor study and review the findings.
Okay.
Okay. Okay. Our next item is a really big one, Objective L. It kind of encompasses a lot of work that COAF is involved in. So it's analyzed data to identify particular obstacles to diverse attorneys' entry into retention and advancement in the profession. And so a lot of the work that we did around this was around the attorney census, gathering all that demographic and satisfaction, work-life balance type data from attorneys in California, as well as the surveying we did related to the pandemic and racial justice issues. And so we have, there are some really broad items here, you know, identify diversity and inclusion programs at law firms, in-house legal departments, nonprofits and government agencies to develop and disseminate best practices resources. This is something we haven't done, but can look at trying to do in 2022. Plan and participate in diversity summits. I think when we publish the report card and impact report together, I think that will be a really great opportunity to hold diversity summits, to share out the data and information, but also get feedback and spark discussion on the data and, you know, potentially next steps that legal employers and attorneys can do. So I definitely think we should keep this item. And change it to 2022. This is, you know, what we're doing with COAF members on the ad hoc commission, as well as, you know, the feedback that COAF gives when we have the presentations at each meeting. This is the loan forgiveness and LRAP, looking at recruitment and retention in the profession. So I think we will try to roll out a statewide LRAP plan next year. And so we should definitely keep this. And then invite researchers or other experts to make presentations to COAF to assist in identifying issues in the development of the pipeline and the profession, starting at the high school level, and to make recommendations on how to address pipeline to the profession issues. So I see some nodding, so it looks like we want to keep that as an ongoing item.
Quick comment or question before you scroll too far up. At that first bullet point, you said we haven't really done that. Is that currently the remit of any of our present standing committees?
I mean, it's loosely related to, you know, diversity report card and leadership seal work, which we haven't done that much on this year. But I think one of the goals is that the leadership seal work would dovetail with the report card. And so I think at that juncture, that's where this would come into play.
Okay, so you're going to change that to next year, to 2022?
Sure.
Yeah. Otherwise, unless that committee is going to do it in the next 25 days or so.
Okay, the next one is
wait. So in the previous one, the invite researchers, can we have someone come and talk about imposter syndrome? Maybe the same person that maybe I think it's the person Heather knows. I don't know. An expert.
Yeah,
Wasn't it
definitely.
who Pat recommended, that Pat just said was
Oh
speaking?
yeah, Pat.
Rod Fong. Is that who?
So I guess Rod Fong is going to be talking about it, but there might be someone like with a PhD in the field or something that might be able
But,
to.
Rod has 3 experts lined up for that, the summit. He could give you some suggestions, and since our meetings are virtual, they're not all from California, but they're experts in their own right, national experts.
Excellent. Yeah, it would be great to have someone talk to us and connect, imposter syndrome with law practice and explain the various, issues and pitfalls that can come up because of it.
Sure. Is that something you want me to do?
Yes, please.
Okay. Okay. No problem. Support presentations to underrepresented high school, community college, university students on how to prepare for becoming a lawyer at programs convened by nonprofits and other appropriate entities. This is an extra word. So that's ongoing. And this really is I think we added this to make explicit that while COAF's charge is really focusing on pipeline and law school moving forward, because that's the state bar's priority, that COAF members, if you are invited to make a presentation or participate in any of those kinds of activities, that you're welcome to. Okay.
Okay, can we say we represent or COAF or something like that? I have no issues with that.
I think that's fine. Okay. I think you can't speak on behalf of the state bar, but you can definitely say you are a COAF member.
Okay.
Yeah. So convene a one-day pipeline summit to obtain a status report on the state of diversity in the profession. So this one, I'm going to actually recommend that we take off of this or edit it because CLA actually puts on this event. And so I think just in terms of not duplicating events and competing, that we either take it off or we talk to them about potentially partnering. They held their summit in February of this year, and they actually just came out with a report. And so Ellen Miller from CLA wasn't able to join us today, but on her behalf, I was going to send the report to COAF that came out of the summit. That's my recommendation, to either delete it or talk to them about partnering with them.
Yeah. I propose that we amend it to talk about partnering with them. Does anyone have any objections to that?
No, I would, if you're making a motion, I'll second it, but.
No need to make a motion.
No, I think that, I think that's a good idea.
Yeah.
And I think Ellen would be, I don't think Ellen would hate that idea.
Okay. And I think our partnership will be more of kind of supporting them, right?
Yeah.
Okay.
Okay, great. Okay. The next item is the video series. So I think we can keep that on. And then the last one for this section is related to the Be a Lawyer brochure. It's just to continue to distribute and publicize it. So I also think we can keep that one on.
Okay. Should we add the imposter syndrome project there or somewhere else?
I think this is a good place to put it.
Okay.
Sorry, I'm just sorry to keep scrolling. I know it can be motion sickness and that all. Okay, so is it develop?
Yes.
Okay.
Develop an internet resource page on imposter syndrome and its impact on diversity in the legal profession.
Okay, I'm gonna say.
Okay, and after, there you go. Okay, perfect.
Okay. Oh, so sorry. I also have a new mouse, so it's sensitive. Okay, is that okay?
Yeah.
Okay.
Does anyone have any suggestions on the language? Okay.
And is this something we want to put a date on?
Yes. I was hoping to complete this project before my term ends as chair.
Okay. Should we say June? Sure. 2022? Okay. Even though your term does not end until September, just to be clear.
Okay.
Okay. Okay. So this, the next objective is related to modifying the elimination of bias MCLE requirements, as well as developing the implicit bias MCLE that I talked about earlier. Very shortly, we will have completed these first two. I mean, we've completed this first bullet point. And very shortly, and this one as well. So we'll be done with those two. I guess my question is, does COAF want to continue to think about other elimination of bias subtopics that we might want to develop a training for, or I know, as I mentioned earlier, COAF might want to think about, right now the implicit bias training that we're publishing is a very basic one. So in maybe 3 years, we would want to do a more, a more complex one, different levels of it, as hopefully attorneys become more acquainted with and understand implicit bias. Is this something that we want to continue?
Yes. And maybe thinking about both implicit and explicit, I was just thinking, as we kind of deep dive into other topics, talking about maybe microaggressions and how that ties into imposter syndrome. To my point earlier about this doesn't just affect law students, but people throughout their professional career.
Yeah, we have a good section on microaggressions in the implicit bias training module, but I think we just introduced the topic, so I think it's a good topic to kind of delve deeper into. Novella, I think your hand's raised.
Yeah, I don't know if this would go here or in a different goal or objective, but one of the things that seems to be pretty common is the different performance standards and how they can be applied differently to white attorneys versus attorneys of color versus women, and sort of digging in on the research about the value of having objective as opposed to subjective performance standards, which I've seen both in a formal setting, but also just in the casual, informal feedback people offer throughout one's career.
Yes, I totally agree with you, Novella, and I'm trying to think of what to call it, because we do talk, similar to how we touch upon microaggressions in this first implicit bias training, we do touch upon kind of the issues you were raising. I'm going to keep thinking about what we want to call it, but for now, just put a note here, objective performance evaluation. And if anybody has any feedback on what we can call that topic, that would be great. Kristen?
I raised my hand like I was in school. One of the things that I think is also something we could do in this area. Several months ago, the NCSC, National Center for State Courts, came out with a study that showed that these elimination of bias trainings don't really move the needle as much as we hoped they would. And so one of the things that a lot of organizations are looking at is what are the next steps? What else can we do after this training to really integrate the things in these implicit bias trainings and get them to get them into people's, get them into people's forefront and keep them there. So I think that that's something that we could look at as a next step training.
Is there a particular expert from, I can't remember the acronym now, that we can talk about that you?
Yeah, one of the judicial organizations that I'm a member of actually had the two researchers who did the study come in and talk, and then we did some, sort of next step training for folks in our group about you know, how to move the needle forward in a very real way. So I can give you their contact info.
Okay. Would the council, would you all be interested if we had, if we could get maybe a speaker to come maybe by February to talk about this, to help inform what we might do?
That's a great idea.
Sure, yeah.
Okay. I think Sarah has raised her hand.
Yeah, I just wanted to climb on board Judge Kristen's comment. You know, there's been a lot of studies done that someone speaking at people about implicit bias is ultimately not effective and not worth the money. And so, you know, I personally have brought in people to my firm to do follow-up and kind of ingrain the behaviors and stuff like that. So I'm happy to be involved in this because I've done quite a bit of thinking about it. But I think it would be helpful to get somebody to come and talk to us about it, or I might have some ideas on who that might be.
Great. Heather?
Yeah, I have a suggestion that I'll send your way to. I can't think of the name right now, but one of the UCLA professors that I've heard speak, who then tied at the end of the conversation, one of the suggestions was about tethering yourself to this, you know, work and making sure that you constantly revisit it. And so that made me think about both the ABA, you know, resolution and the 20 hours and how that's a way you can leave the training and then have a tangible goal to be kind of working towards to integrate it into your actual practice. And then that made me think, how can we maybe extend the badging concept that we're thinking about for companies and law firms to individuals? Like if you completed 20 hours of a minimum of 20 hours of D&I work or training or something, could you get some kind of recognition for that, whether it's some kind of badge on your bar card or some acknowledgement on the website or something that would help incentivize people to stay tethered to the work beyond just a training?
That's an interesting idea, Heather. It reminds me of just relating to pro bono. In the past, before the state bar, before CLA separated from the state bar would issue Wiley manual certificates, which would recognize an attorney if they completed 50 hours of pro bono service in a year. And when the bifurcation at the state bar happened, awards and certificates like that went with CLA. So that might be something we could partner with CLA and talk to them about, because I believe they are continuing issuing that pro bono certificate. So that might be a good collaboration.
Can I jump in here? Is that okay?
Yeah, sorry. I because I'm sharing my screen, I can't see everybody. So please.
Yeah, I was going to say, Michelle reminded me of the UCLA professor, Jerry Kang, who's done a lot of thinking in this area. I heard him speak at LCLD the other year for about 3 hours of training on this. And we actually brought him into Varela for our NCLE day just a month ago. So he's fabulous. So if we want to keep it to somebody in California, he's somebody who we could reach out to. He's done a lot of thinking and scholarship in this area and is a terrific speaker too.
That's exactly who I was thinking of. He came to speak to us at Disney too, and he was fabulous.
The state bar may not be able to afford him, but we will try because we've reached out to him in the past. Okay.
Maybe he'll do a deal.
State bar can't afford
it. We are a government agency. Okay.
Maybe a firm will invite him and we can be their guest. Like COAF can be their guest to come and watch when he speaks. Anyone who has those connections.
I love that. Yeah, I'm sure the state bar has some influence there on law firms.
I know some people who are friends with him. I can make some calls too and see if we can't put pressure.
Okay. Okay, so then moving on to the next item. So this, I think, will definitely be probably coming off of the strategic plan, developing an annual report card or as a specific objective, because I think this is just something we are going to continue to do. I think just, you know, my guess would be that the Board of Trustees will make this a broader objective related to attorney data. So I think, you know, this very specific items here related to the report card and calls to actions, as well as the impact of the pandemic survey, we've pretty much completed for right now. But I think COAF will have a hand in reviewing, continuing to review the data moving forward. So I think just adding kind of a broad item here. And I can flesh this out a little bit more, but related to, you know, reports that the State Bar will publish, if that's okay.
Sure. There's one thing I would like to also include on there, and that has to do with violations of Rule 8.4.1, prohibiting discrimination, harassment, and retaliation. I would like that to be also reviewed by COAF as well. Like how many people, the number of the data. Yeah.
Okay. So the next item was very specific. It's, you know, partner with the Judicial Council to complete the Judicial Diversity Toolkit. And I believe we finished that in 2016 or 17. And so we have some broader items here, just provide assistance and support to Judicial Council in implementing judicial diversity efforts, support the council in conducting workshops, meetings for attorneys interested in exploring judicial positions, and assist the council in delivering such programs. If requested by the council, provide consultation and assistance to the council for the 2021 Judicial Diversity Summit being held by CLA and the California Judges Association.
Which already happened.
Oh, right. That is right. That was actually a really great event. So we can.
That already happened.
Yeah.
And it was great.
Mm-hmm.
All right. Let's see if...
I wonder, I'm sorry, I can't raise my hand and unmute at the same time, apparently. I don't know whether we want to include a reference to the 2026 Judicial Diversity Summit, because I know that there was conversation already about planning that and whether there will be any asks from Judicial Council.
Sounds good to me. Judge Dolchich, is there anything that you think we should add here, or does it look good to you?
I don't have any information on that. I know Catherine is listening. She's got her hand
she's
up, maybe.
raised her hand. Kim, can you promote her?
All right, welcome back, Kathy.
Hi, everybody. I'm Kathy Ongiri, and I serve as lead staff to the council's providing access and fairness. And so in terms of the 2026 Judicial Diversity Summit, is that what the questions are around right now? So we're still finalizing the stuff from 2021 because we're getting ready to work on some recommendations and issuing those. So after that gets done, because in the next 5 years, once the recommendations come out, we'll be implementing them. And then that will lead into the 2026 summit. So there's been preliminary talks, but nothing solid yet.
All right, thank you.
So maybe it's a little bit premature to talk about 2026, but I think these two are sufficiently broad, and perhaps Ryan and Kristen and I will do a little bit of wordsmithing between now and February.
I mean, the thing is that there could be potential to help implement the recommendations. So that would be maybe something that you would want to continue on, the implementation of the recommendations from the 2021 Judicial Diversity Summit. I don't know, just kind of throwing that out there, because that may be something that we need assistance with.
Great, thank you, Kathy.
And I'll just stay up here in case Judge Dulcich needs anything else during her liaison report.
Thank you.
Okay, thanks.
Okay, so that's the work plan. I think we did a good job in just kind of updating it with the information that we have so far. I think we'll learn a lot, or maybe not, but we'll have additional information once the State Bar's Board of Trustees does their strategic planning on how that impacts COAF's work plan. But I think this is a really good start. Once I have that information from the Board of Trustees, I will work with Kristen and Ryan to kind of fit things into the right places, and we'll present it again to you all in February. And if there's additional things or ideas that you have, we can add it at that time. We can discuss it and add it at that time.
Excellent. Okay. Does anyone have any comments, concerns, or questions before we move on to the next item? All right, seeing and hearing none, we'll move on to section 5, liaison reports. And up first we have section A. I don't see Kenneth here. Is anyone here able to give a report on CLA?
I can't give a full report for CLA, but as I mentioned, they did publish their report on their pipeline summit. It was the inaugural summit for diversity stakeholders. So it's available on the CLA website, but I will also send out a link to COAF after the meeting so that you can take a look at that report.
Thanks, Elizabeth. All right, moving on to section B, California Law Pathways Report on Diversity and Inclusion Initiatives. And here we have Pat Lee, our liaison, who will provide that report.
All right, thanks, Ryan. There are just a couple things here that just to give you an update. On December 9th next week, we'll be doing a program on critical race theory. It's called Critical Race Theory, What It Is and What It Isn't. And Dean Kevin Johnson from UC Davis School of Law will be leading that discussion. We felt that this was really important to do for our pathway partners and anyone else who's interested in this, just given the issues and the discussion and the controversy here on critical race theory and the education system and so forth. So he'll be describing the concepts, how it was developed, how it originated, what it really means, reviewing the debate around critical race theory, debunking any opposition that is really misinformation and incorrect. He'll be comparing critical race theory with the requirements for all levels of California education within the next 2 years to include ethnic studies as part of their curriculum in the public schools, at the community college level, and at the UC and the Cal State levels. They will all be required to incorporate ethnic studies as a part of the requirements for graduation. So we've asked him to compare that with critical race theory, how it differs and what the curriculum would look like. And then he'll be sharing some of the law school curriculum from the Davis School of Law about critical race theory so that the faculty and teachers who are participating in this program will get an idea of how that gets incorporated into their lesson plans. I wanted everyone to know that the deadline for the annual Education Pipeline Award was extended to December 15th. If any of you are part of organizations or know of organizations that are really doing a great job in terms of educating students about the legal system and about potential law-related careers, please either nominate them or have them self-nominate. We want to have as many of these programs nominated so that we can be sure that we're identifying and recognizing the best programs each year. I haven't seen these submissions yet, but I know that there are programs out there, and I could call them, but I probably shouldn't because I'm on the board of Cal Law. But those of you who are involved with all these pipeline programs in your work, please encourage them, or board members or other participants, volunteers in those programs, to submit nominations on behalf of those programs. Again, that deadline is December 15th. We decided that we needed to post more resources on our website for students traveling through the pipeline, making transitions from high school to community college, undergrad, and law schools. So we're developing a series of 3 resource documents to provide direct information to students at each of those levels as to how they get to the next level in the pipeline. So we have a flyer that is directed to our community college pathway scholars on how they can go about transferring to the undergrad level, and how they can take advantage of their designation as pathway scholars and what benefits those hold for them as they apply to their undergraduate levels. And then we have another flyer that's been developed in terms of applying to law schools with similar information and the kind of contacts that they should make at those different levels so that they stay within the system and can benefit from their participation in the pathway. And then we have a one document, it's like a flow chart that shares a sample law school curriculum, that shares the curriculum and the ways that the students can move along the entire pathway from high school law academies to the community college pathway scholars to the 4-year undergrad and then to law school. So we want to just be able to give the students in our pathway as much information as possible, and how it benefits them to be part of that pathway and to move successfully and smoothly along that pathway, and hopefully eventually getting into the law school and taking the bar exam. We're at that period now. When we first created this pathway program, we realized it would take 10 years for any student starting from high school to get through law school and to take the bar exam and pass the bar exam. So we're now at the stage where we actually have students who are at that far end and who have taken the bar exam, and some of them have actually passed the bar exam. So we're also at the point where we are also looking at ways that we can formally and correctly collect the data in terms of students traveling along the pathway, how many students are in each level of the pathway, how many have been successful in completing all the stages of the pathway, so we can show the type of impact that we're making in terms of increasing diversity in the legal profession. I mentioned the Pathway Summit. The 2 areas that we will be focusing on, one was what you've already discussed in terms of identifying and overcome invisible barriers to student success, imposter syndrome, and lack of belonging. Those sessions will be directed to both students and faculty and other volunteers who work with the students in the Pathway program, so that they can identify those concepts, how they play out in the classroom and elsewhere, and how to overcome them. They'll be given the opportunity to discuss personal experiences and how these concepts affect them in school and elsewhere. And then they'll be given ways that they can address those concepts, how they can overcome them and become more successful in their student and professional careers. And then also finally, we will be we're now in the process of recruiting an executive director for California law. We've had executive directors in the past. Currently, we're relying on staff from the Foundation of California Community Colleges, and we're going to be transitioning to a full-time executive director. So at some point, we'll be posting an announcement recruiting an ED. When we get that final announcement, I'll send it to Elizabeth, and you could share it with everyone on the council. And you can go to our website as well. It's CA Lawyers, www.calawyerspathway.com. And you can see anyone who's interested in possibly considering being the executive director of the organization can go to that website to see all the levels of the work that are done, what kinds of activities are involved, and get a good sense of what the responsibility will be. The job announcement will be posted on the website. And if you have any questions, you can contact me. And Ryan is a liaison to the Cal Law Board as well. So this will be kind of a very widespread recruitment process, because the person that we really want has to know about the pathway, know about the different levels of the pathway, have a legal background, have an education background, and be able to work in an academic setting as well as the legal setting. So it's a very all-encompassing process, and it has to be someone who's really good at outreach and recruitment and getting more volunteers to be involved in contribution to resources and so forth. So keep that in mind and start thinking about people that you know of, or if any of you are interested, just to be able to consider applying for that position. And thank you.
Thank you. Thanks for the report, Pat. I always appreciate the good work you're doing. Does anyone have any questions for Pat Lee? All right, seeing and hearing none, we'll go ahead and move along to the next item, item C, the Judicial Council report.
Thank you, Ryan. I'd be happy to provide an update on diversity and inclusion initiatives from the Judicial Council. And I think Catherine is still online with us as well, and I'll ask her to hop in at the end if I've forgotten anything. Diversity in the branch continues to be a priority, and we recently concluded the Stronger Together 2021 Judicial Diversity Summit. The summit was a success, and we had panels on the many aspects of creating and maintaining a diverse judiciary. The summit had over 400 people in attendance over the pre-sessions and 3 days of programming. The advisory committee for the summit has reconvened twice to provide general feedback and takeaways from all of the sessions. The sponsoring agencies will continue to work with the advisory committee, drafting recommendations for review and consideration. The recommendations will inform the plan for the sponsoring agencies to implement during the next 5 years. Additionally, the Judicial Council continues to work with the Judicial Nominees Evaluation Commission, commonly referred to as Jenny, to provide training on judicial diversity, bias, and the effects of decision making. The next training is scheduled for January 29th. And that's it for my report. I'll just check with Catherine, make sure I didn't forget anything.
Nope, that was perfect. Unless anybody has questions, I can help with those as well.
Thank you, Judge Dolcich. And Kathy, does anyone have any questions? All right, no questions. Well, thank you so much for the work that you guys do in the area of judicial diversity. I keep celebrating every time the governor announces new appointments. Might I add, one of the recent appointments, Andre Campbell, is a friend and mentor of mine. So I was very happy to see him be elevated to Sac Superior Court.
Yeah, you know, just from a personal perspective, I've watched my bench. We're a medium-sized county in the Central Valley. I've watched my bench change. I started practicing 31 years ago. It is a very different place, and we still have conversations about what it was and what it is now. And it is that inclusion of diversity that has changed us for the better.
Excellent. All right, so we have no remaining items. Is there anything else that's pressing that anyone would like to discuss related to the agenda? I see Shalak, she has her hand raised. Go ahead.
Yes, and I'm not sure if this is, you all may tell me this is either A, not related to the agenda, or B, not appropriate for this group. But it just came to my attention because I was asked for a comment from my institution and wondered if anyone here would be able to provide me with any thoughts on the California paraprofessional proposed program. And specifically, my institution asked me for thoughts on how supporting it may impact diversity in the legal profession and access to justice diversity. And given that, you know, I was asked Wednesday or yesterday, I thought, well, maybe we'll discuss it at this meeting so I can allow that to shape any feedback that I provide before they provide comments. So I apologize if it's not appropriate for this group, or Elizabeth, you may say to email you separately, and I'm happy to do so. But I just thought if we're finishing early, you all may be able to take 5 minutes and give me any thoughts that I can share back as well.
I think you highlighted a very significant issue that we didn't include for this meeting, and I don't know what their timeline looks like, but I would like maybe to examine this at our next meeting, and we can have somebody who is the person most knowledgeable speak to that, because there's a lot that I don't know about that.
So I know comment to the state bar is due January 12th. And so there are, I have a few weeks to get my thoughts to the school, but I don't know that it's in enough time for this body to have someone knowledgeable comment on it. But given that it came to my attention, I thought that I saw immediate overlap between much of the work that we do in various subcommittees in this body. So I just thought I would raise it.
Mm-hmm. What are your thoughts, Elizabeth?
I apologize for the oversight because the paraprofessionals is something that our Office of Access Inclusion that we have worked on. So I apologize for this oversight and not kind of, bringing this kind of crossover issue to the council. The public comment period does end, I think Shalaki said July 12th. It was 110
January.
Oh yeah,
12th is
January.
what I was
I'm sorry.
told. Yeah.
It was 110-day comment period, so I don't think it will be extended. I also think it's not typical for necessarily for a sub-entity as a whole to comment on something that the state bar is doing like that. We would typically get your feedback kind of along the way. So if you as individuals or as your firms or organizations would like to make comment, you're welcome to. There is a lot of information about the paraprofessional work, I believe on the State Bar website that's available, that I could direct you to.
Oh, I just realized we don't have chat. I was going to drop the link in the chat, but I just realized we don't have.
And Shalak, I think one of the key factors in revisiting the paraprofessional issue, it has been revisited a number of times by the State Bar over many years, is that it's trying to increase access to the justice system for individuals who can't afford to pay for the attorneys in the kinds of services that are appropriate for paraprofessionals to engage in. And when you look at the statistics for low income and moderate income, those are many of those clients are diverse. So the issue is, are you increasing representation on behalf of diverse clients? But in terms of who the paraprofessionals are, personally, I don't know what that diversity number looks like. So.
Thank you, Pat. Yeah, my institution asked me to comment to them on both sides as we try to make sure that we're increasing access to justice. How do I feel this may work, as well as pipeline programming to the profession? So I thank you all for allowing me to raise this, and I've dug into some of those materials, Elizabeth.
One other thing too is that I think I saw in some of the information that one of the groups that would be eligible to apply to be paraprofessionals are those individuals who haven't passed the bar exam but have graduated from law school. So that might be a factor as well.
That's correct.
And without having looked into it with any specificity, I guess my general concern has to do with, I call it policing the line. If you're able to be a paraprofessional and have a limited scope of ability, who's gonna, I guess, ensure that you don't cross the line to other areas that you're not licensed to practice in? I mean, is it gonna be until someone actually gets hurt?
I think your concern, Ryan, is part of the proposal that's out for public comment right now. There has been a California paraprofessional working group studying this and coming up with these proposals for, I think, the last 2 years. And so it's a pretty comprehensive document that they've put out for public comment. It may be thousands of pages, if I'm not mistaken. I can forward you that information, forward the council the information. And if anybody wants to make individual comment or comment on behalf of your organizations, that's the, I think, appropriate place to do it.
And allow me to just say, to Elizabeth's point, it is a very thorough and well-researched and thought-provoking document across the board. And Elizabeth, you can convey to your colleagues that I mean, I think regardless of where you fall in the program, it was extremely well done. Thank you.
Thank you, Shalak. And I would also add that Judge Erica Yu, who was our former liaison from Judicial Council, she was on that working group and did a lot of work on it.
Okay, yeah, that would be great if you could send that out to us. You said 1,000 pages?
If not more. It's substantial. That's why it's a 110-day public comment period. Typically, our public comment periods are 30 days, but we wanted people to be able to get through all those documents.
Does it have a lot of pictures?
Charts and graphs, maybe.
I'm kidding. Oh, well, thank you, everyone. I think we're at the time to adjourn if there's no other items to discuss. And I really appreciate you guys' time today to address this very important issue. And I'll go ahead and turn over to Elizabeth. Elizabeth, is there anything else to discuss today or anything like that?
I don't think so. Just please be on a lookout for calendar invites for our 2022 meetings. Kim will be sending them, so keep an eye out for her name in your inbox. And I just want to echo Ryan and thank everybody for their attention and time and thought-provoking questions and discussion today. I thought today was a really excellent meeting, and we accomplished a lot and are ending early, which kudos to everybody.
Thank you. All right, until we see each other again, have a great day.
Okay, happy holidays too.
Happy holidays, everybody.
Happy holidays all.
Bye.